Recording in progress.
Honorable members, good morning.
Morning, Chair.
Morning.
Honorable Dagmo, thank you for joining us. We haven't seen you in a while, sir. Welcome back.
Thank you, Chair. When you get to apologies, I'll have to explain that I have to leave at some point, but thank you very much.
No, that's fine. Thank you very much, Honorable Dagmo, and good morning, honorable members. I've received 2 apologies so far. I may be incorrect, but Honorables Kosan and Honorable Nondenja have got flights that they've got to be on. So I'm expecting they either won't be on or they'll be on for some time and then leave us. But thank you very much. And also good morning to members of the Parliament staff that support the committee staff. Good morning to you, and also good morning to the members of the SIU team, Advocate Motibi, and your team. Good morning and welcome. I think it's the second time that we are together this week. I'm not complaining. We are going to have weeks like that from time to time, but thank you very much. So the notice has been sent, and today we're getting an update on the Special Investigating Unit's work at the Road Accident Fund. I am going to hand over to you, Advocate, to then take us through the presentation with your team. Obviously, you will introduce your team that joins you. It's very difficult when we're not in the room together. Yes, so just introduce your team and then take us through the presentation. Thank you so much.
No, thank you. Thank you, Honorable Chair and honorable members. I'm joined in the meeting by the Chief Operating Officer of SIU, Mr. Leonard Lekgetho. I'm also joined by the Chief National Investigations Officer, Ms. Zodwa Kresibe. The Chief National Investigating Officer oversees all the national investigations. And by national investigations, we refer to investigations at national departments and state-owned entities at a national level. In the provinces, we've got the heads of provinces that are responsible for those. I'm also joined by Mr. Khanyago, who's the head of communications and stakeholder relations, also the spokesperson for the SIU. I'm joined also by Advocate Vanara. He's the Chief Legal Counsel. His responsibility, amongst others, is to ensure that the outcomes that are reached out of the investigations, and where there's a need for civil proceedings, he heads that and refers the matters to now the special tribunal. But in some instances, we have litigants referring SIU reports to the ordinary high courts. And in that case, we also go to the High Courts, and he leads the SIU defense in that case. Honorable Chair, there's also the lead investigators that are in the meeting. Whenever they are required to come in, I'm sure they'll introduce themselves at that time, just in the interest of time. Honorable Chair, that's the team. We are ready to proceed. If you can go to the next slide, please. Right, really this is just the outline. We will go straight into the slides. Next slide. Honorable Chair, well, this is the background, really just that indicates that we are aware of the objectives and the mandate of REF. And just the bullet point number 3, I think it is very important to note that this investigation ensued based on a report that we received and an affidavit that was provided by a REF senior manager forensics. This would have been the work done internally at REF. And also as well as a letter dated the 5th of March, 2020 from the Road Accident Fund to the Legal Practice Council. Amongst other matters contained in the said affidavit was the issue of the duplicate payments, Honorable Chair and members, which we have reported on before, but will give an update today, as well as the matters relating to tender irregularities. So we took all of those into account when we drafted a draft proclamation that went to the President. And of course, the proclamation was signed, Proclamation R44 of 2021, which were the allegations referred to SIU, which upon evaluation, of course, we found that they were worth investigating and that they fell within the SIU mandate. Next slide. The proclamation, just really this is high level, not in detail. We have really outlined this before, but I think it's very important to really just keep remembering that this proclamation provides for the investigation of, number 1, serious maladministration in the Road Accident Fund in respect of compensation payments made by REF to claimants and claimants' agents, and payments made by REF to service providers in a manner that was contrary to applicable legislation or any manuals, guidelines, practice notes, or instructions issued by the National Treasury, or manuals, policies, procedures, prescripts, or any instruction or practices that are applicable to the Road Accident Fund. And those then would have been made in a fraudulent or corrupt manner. We had then to investigate that. But additionally, we have to investigate any other losses or irregular or fruitless and wasteful expenditure incurred by the Road Accident Fund or the state. Of course, the Road Accident Fund being a state institution, those would invariably be losses by the state. We also have to investigate any irregular, improper, or unlawful conduct by officials or employees of the Road Accident Fund. And this does not differentiate. It's officials or employees at all levels of the institution or any other person or entity in relation to the allegations which are set out in part 1 of the schedule. So we didn't include the schedule here because that's the details I'm referring to. But in the investigation, the matters covered in the next slides are those that are covered in the schedule. Next slide. So once the proclamation is signed off, Honorable Chair and Honorable Members, we thought it appropriate that we really just appraise the Honorable Committee in terms of what is the engagement method with the state institution. Because we have really found that in some instances, there are confusions created by the manner in which we engage state institutions. It also occurred in the investigation at the Road Accident Fund. So it is important to note that prior to 2012, and this is really a historical background, once a proclamation is issued, the SIU used to enter into what was called service level agreements, Honorable Chair and Honorable Members, with the state institutions, right? Now, this service level agreement created really legal issues to the extent that it may actually have impacted on the independence of the SIU relating to specific investigations. Now, as a result of that, at the time, the SIU sought a legal opinion from senior counsel on just the legal implications of the service level agreements with state institutions. Now, the opinion almost confirmed what SIU was of the view that this service level agreement, because it really results in an agreement between SIU and the state institutions, and that's not the ideal situation to enter into such agreements with institutions such as SIU. I would say even other investigative institutions in government, because that agreement invariably, impinges on the independence, and the legal opinion confirmed that the service level agreement is not appropriate. It will invariably infringe on the independence of the special investigating unit. And then, of course, another mechanism was considered. That's the mechanism that is used at the moment, which we call a letter of engagement. Because really that is just to say, state institution, in this case, Road Accident Fund, the proclamation has been issued. We are commencing the investigation. Now, we are saying under the third bullet point that the purpose of this letter of engagement is in the main, amongst others really, to inform the state institutions management on the approach that will be followed by the SIU to investigate the allegations as set out in the proclamation, and provide the management with an indication of cost estimated timeframes, would add also estimated resources in respect of the investigation. It is important, Honorable Chair and Honorable Members, to note that the letter of engagement does not dictate or does not even include an investigation methodology. In terms of the Special Investigating Units and Special Tribunals Act, the head of the Special Investigating Unit has to determine a methodology based on which the Special Investigating Unit will investigate. And that methodology is contained in what we call standard operating procedures at SIU. Those procedures are used then by the investigating teams. The letter of engagement is not even part of that methodology. the LOE really is to really assist with the, call it, sort of project management aspects with relation to the state institution. Now, the letter of engagement is signed by the head of the SIU, and is not signed like an agreement where the other state institution has to sort of sign in agreement and so on. Although we expect them to acknowledge the receipt. It is important to note that the LOE, which is the letter of engagement, also indicates a nodal person. Now, this is very critical because in the slides that are coming, we are going to be indicating that now, when we require some documents during the investigation, just so that there's efficiency in the investigation, the state institution, in this case, REF, would have appointed or at least nominated someone that the investigators would go to in request documents and all of that. And all of this, Honorable Chair and Honorable Members, we are saying there, it is done to safeguard the independence of the SIU and its investigations. So we thought it appropriate, Honorable Chair, to really outline this. The next slide, please. Oh yes, this is another part, Honorable Chair, which we thought we would outline, upfront before we get into the actual update. As the Honorable Chair and Honorable Members would know, would probably be aware, this is an established legal principle that where the investigations reveal evidence that points to wrongdoing on any part, on anybody or individual or entity, that individual is expected to be given what is called the right of reply. The Latin term is audi alteram partem, and that's the rule that we apply to ensure that, as it says, audi really refers to the hearing, hear the other part, hear the other party, so to speak. So the party is given the opportunity to say and present their part or their version so that we take into account in finalizing the finding. So what do we do? Upon concluding of our investigation, and in certain circumstances where it's legally prudent, SIU affords any person affected by its adverse findings a right of reply. And a person, Honorable Chair, would include a juristic person, which is a company or any entity. Right, as I indicated, a right of reply is part of the investigation process, whereupon the affected person is afforded an opportunity to address the SIU on its preliminary finding against such an individual. As part of the investigation process, SIU will then, in certain circumstances, as I said, where it's legally prudent, afford persons of interest with the right of reply in respect of our findings against them. The response received from the person is viewed in a serious light, of course, as it is instrumental for concluding the findings. In the REF investigation, Honorable Chair, we noted with concern at some point a directive which was issued by the Road Accident Fund to its employees in respect of this right of reply process, wherein the directive indicated employees were directed to forward their right of reply to SIU. Such right of reply were to be forwarded to REF management, such that the response to SIU would be well coordinated. Chair, we viewed the right of this directive as having a potential to compromise the investigation, and it could amount to interference. I say it could because we clearly had to engage with management to ensure that it doesn't really compromise the investigation and it doesn't amount to interference. By doing so, we then, after receiving a correspondence from REF, we directed a written correspondence to the Road Accident Fund Chief Executive Officer in this regard. We hope that the CEO will consider our correspondence and, of course, respond to us as appropriate. Right. If you go to the next slide, Honorable Chair, we are often in a position where we observe the process and whether there's any cooperation or no cooperation, particularly by the because we get to deal with the nodal person who's the entry position. So in this investigation, Honorable Chair, we thought it appropriate because it's very important. Because as we say at the second last bullet point, we're saying this causes delays to the investigation. Now, what is the nature of the delay here? So we would, for example, request information through or from the nodal person. So such information would be requested, of course. We're mentioning a section from the SIU Act, which then we expect that the information be provided. But in this investigation, we have really observed some delays. Some of the requests, even as we speak, have not been responded to. But we will be engaging with the Road Accident Fund on this. However, I think it needs to be very clear that, and again, without really going into the legislation in detail, this is a Section 52A, which really says we request document within a specific time. If they are not provided within a specific time, there's a Section 52B, NC, I would say, which then authorizes the SIU to sort of formally subpoena the documents. And I have said to the teams that in appropriate instances where we observe undue delay, then we need to invoke the next subsections of that Section 5, which would then be a formal subpoena, so that, Honorable Chair, we don't come to SCOPA or we don't go to REF and say, we've experienced delays, as though we are helpless. The law provides the Special Investigating Unit with the provisions of ensuring that we are able to secure the evidence that is required. And after applying the next subsections, then we'll obviously take it from there. We expect that there would be cooperation in that regard. So, Honorable Chair, as I said, there were instances where the SIU had to resort into opening a criminal case against the REF executive for failure to adhere to a lawful subpoena issued by the SIU in terms of the SIU Act. And that is really, the consequences of failing to adhere to our request or our subpoena. So as we said, the above delays have got a serious potential to delay the investigation. Honorable Chair, we have received a formal request from the SIU, from the REF, Accounting Authority to come and present our preliminary findings. We will be arranging to go and present to REF at a time that is suitable for both the Accounting Authority and the Special Investigating Unit. So we thought it appropriate just indicate this kind of landscape. But of course, you know, we will continuously engage with REF so that there is the cooperation that we expect. Let's go to the next slide, please. All right, Honorable Chair, at this stage, I thought I would hand over to my colleague, but anyway, I think this is where now the investigation hits the ground, where we start really investigating, as we say. These are the focus areas now, and this would be some of the focus areas that are in the schedule that we did not attach to this presentation. We are investigating procurement and tender irregularities, fruitless and wasteful expenditure as well, duplicate claims and payments made by attorneys, claimants, and sheriffs, and some change of mandates. And then, of course, we are investigating payments made to service providers in terms of the REF Act, and then invoices submitted to REF. I think we've looked at that, including bills of cost and other related costs. Any other fraudulent claim, we are also investigating that part. Honorable Chair, at this stage then, I will hand over to my colleague. At last check, Mr. Lekgetho or Mr. Sibe, you take it from here. Honorable Chair, this, as we say, this is an update as we have presented before. I'll hand over to my colleague to proceed from here. Thank you. Okay. Mr. Lekgetho, please. I can't hear. Hopefully you're not muted.
No, thanks, Advocate. I'll take it from here. We had arranged that the CNO will take it, but I will take it. So this slide outlined some of the contracts that are currently under investigation and where there is a possible referrals to the special tribunal for the cancellation of some of this contract. The first one is relating to the panel of attorney, where the acid test is on the rationale of the decision taken by the RAF to do away with the panel of attorney. On this one, investigation is complete, and investigation is complete, and the team is finalizing referrals for civil litigation. The next one is expenditure on the Sienza contract, which was 313 million, and the investigation on this one is also complete, and evidence is being reviewed by SIU civil litigation lawyer for referrals to special tribunal. The other matter relates to the office building contract, which was 17 million. And this one also, the investigation is complete. We are finalizing referrals for civil litigation. The other contract is the fleet contracts for 53.1 million. And where also we are finalizing referrals for civil litigation. The cleaning contracts, 12 million. And the subcontracts, 1.8 million, and the office furniture contract, which is 40 million. All of them are being finalized, where we are looking at finalizing the referrals to civil litigation, whereby they will start with the civil litigation to cancel the contract. So the first one we're gonna deal with is the panel of attorney, where it is alleged that RAF cancelled the panel of attorney without a backup plan in place to service the claim. On this one, RAF has the panel of attorney that represented it in court involving the claim dispute. However, when the contract was coming to an end, which is 6 months to an end. A 6-month extension was requested, citing that the reason for the extension was that RAF was still busy with the evaluation of the tender, and it was taking longer to finalize the evaluation process. And the contract with the panel ended in May 2020. The tender under evaluation was subsequently cancelled, and the RAF has since forgone the use of the panel of attorney. And at the time this occurred, it appeared that RAF had no backup plan in place as to who will represent the RAF in court. Then the RAF then decided to use the service of state attorney. However, the process to get the state attorney appear in court took longer, and at this time, the RAF had no representation in court for at least a period of 12 months. And the memorandum of understanding between RAF and Solicitor General was signed, whereby the first batch of 62 state attorneys were appointed in September 2020, but they were appointed without the right of appearance from the state attorney. And it took 6 months, which is a 12-month delay, for the state attorney to have the right of appearance in court to the appointed attorneys. And the SIU interviewed the RAF former and current board members, including the RAF CAO, to establish the rationale of the foregoing of the use of the panel of attorney. The SIU is establishing the rationale of the decision was to compute the financial impact arising from the decision. The decision to not proceed with the contracting the panel of attorney was not approved by the board. Safe to say, the board approved a strategy wherein the RAF had to reduce its administration costs, including the legal costs. There was no plan adopted to replace the panel of attorney, even though RAF contend that the RAF employed practitioners and seconded them to the state attorney to represent the RAF, seemingly as mere ex post facto afterthought. Then the SIU noted that there has been an increase in default judgment issued against RAF since the termination of the panel of attorney. This resulted in RAF incurring unnecessary expenditure on legal costs and paying more than they should on claims. The impact of foregoing the use of the panel of attorney and lack of representation caused an increase in default judgment, and the total amount of default judgment issued against RAF for cost and fee from 2018 until second quarter of 2023 amounts to close to 4.7 billion, and this amount is cumulative. Among this default judgment lies a claim which may have not warranted substantial settlement if defended. The impact is further illustrated in matter where a claimant was awarded a default court order amounting to 11.1 million, which RAF failed to honor on time and led to this amount accumulating interest worth approximately 500,000, which was paid out on the 24th of January 2023 in respect of the claimant. The RAF appeared to have acted irrationally by presenting a report to the board seeking to cancel or doing away with the panel of attorney without a plan in place, and the board appeared to have acted irrationally by approval of the strategy of doing away with the panel of attorney without any plan in place. The rationale for such decision appeared to be flawed in both administration and in law. The SIU is preparing the necessary evidence pack for referrals relating to disciplinary administrative action and civil litigation against all members responsible for causing loss, damage, and contravention of the relevant law. And in terms of corporate panel, in terms of the RAF supply chain management and delegation of authority, the CEO can approve a contract up to the value of 1 million and the board can approve anything above the 10 million. We are outlining this because it's going to be relevant in terms of what we're going to outline in terms of the corporate panel that was sourced. The RAF has appointed corporate panel of attorney through a treasury regulation from the GEPF to represent RAF on its internal matter pending the RAF conclusion of its tender. Then the RAF wrote to GEPF requesting permission to participate in the contract for corporate panel of attorney through National Treasury Regulation. The 5-year GEPF contract was left with approximately 3 years to end. That is, the corporate panel was contracted for pension law and employee benefit litigation, and also for commercial law and corporate law and investment advisory and compliance advisory services. These are the services which were the corporate panel for GEPF was appointed for. And the GPF consented to the request and provided RAF with the bidding documents demonstrating that they followed the bidding the process in a competitive process. Then the GEPF had 19 law firms contracted with it, but it appeared that the GPF only sent 14 service provider, that is law firm, to RAF in order for them to utilize as their services for corporate panel. RAF entered into agreement with the service provider between May and June 2020 for 10 months, and there appeared that one service provider appointed by RAF did not form part of the GEPF corporate panel of attorney. Whilst the board approved that the RAF participate in the GEPF corporate panel of attorney, it appeared that the board did not approve contracts entered into between the RAF and GEPF service provider in terms of the National Treasury regulations. The contract was extended for a period of 6 months without the RAF board approval.
Sorry, Mr. Lekgetho, I just, if I may ask just a clarity-seeking question, if you can go back to the previous slide. I'm sorry for interrupting. So when you say, for instance, and this is just an example I'm picking up, right? So whilst the board approved that the RAF participate did not, but in the GPF corporate panel of attorneys, it appears that the board did not approve the contract entered into between the GPF. How do you reach that conclusion? So is it because you asked for such approval? So A, is it because such approval was necessary in terms of the rules? And secondly, the RAF could not produce a record of such approval. I just want to be certain about what this term means, where you use it.
Okay, thank you, Chair. Maybe I can ask the lead investigator to come in, either Mr. Maseko and Advocate Lebopa, so that they can confirm how did we come to that conclusion.
Yeah.
Mr. Lebopa and Advocate Lebopa.
Oh, thank you very much, Chairperson Maseko. The question, the response to the answer is that we have requested information from the Road Accident Fund, and from the information that were received in terms of Section 5.2a, what was provided, it appears that it was only the approval to participate, and we could not receive any information that suggests that the contract entered into was approved by the board, and that we take it from the delegation of authority that Mr. Lekgetho have already spoken to, that in terms of entering into the contract that are over 10 million, there ought to be an approval that will come from the board.
Okay. No, I just wanted to be clear. So in other words, for contracts 10 million and above, board approval is required. In this case, there is no such approval that was obtained once it reached 10 million and above. Basically, there should have been, and no such. So there is no record of decision to that effect.
That is correct, Chairperson.
Okay, all right. No, thank you. Okay, now I just wanted to be sure, because when you say appears, it's like it can feel like we heard or we took a cursory look and we didn't. Yeah, anyway, I think I'm clear. Please go ahead, Mr. Lekgetho.
No, thank you, Chair. Like I've indicated, the contract was extended by 6 months without the RAF board approval until September 2021, as indicated that the amount exceeded the level where it needed to go to the board, and payments made in terms of the contract so far totaled to 26.6 million and appear to have exceeded the delegation of the RAF CEO. Furthermore, the expended amount is above the total contract price, which is 10 million, which is according to the delegation. And the ratification of both entering the contract and exceeding the delegation amount, including the extension, was done a year later in August 2021. The RAF board, through its chairperson, approved the ratification and extension of the contract. And it appeared that an estimated total amount of 141 million was an irregular payment, since there was no approval of the board nor the Special Operation and Information Technology Committee for the contract or extension when appointing corporate panel of attorney. The SIU conducted financial analysis, including back statement of the attorney appointed in the RAF corporate panel of attorney, and the preliminary findings suggest that some of the RAF executives were possibly paid monies by the attorney appointed in the RAF corporate panel of attorney. The investigation is still ongoing on this aspect, and once we come to a conclusion, we will be able to indicate.
Sorry, can I also ask here? So can you just give a sense, and I'm careful that you don't mention anybody's name, please. So what does this mean? What leads you to the conclusion that monies were paid to RAF executives? How would you even be able to identify who the recipient is, or is that coming?
In terms of this process, Chair, as indicated there, that we have done the financial analysis. In terms of our investigation methodology, when we conduct the investigation, we identify the person of interest, and we follow the money. As the money is being paid to the other side, we follow the money until we see where the money goes. I think that's how we were able to identify the payments. And we also do profile. We profile all the person of interest so that we can be able to see all the money that is coming to them, and we are able to link it back to any contract that is linked to the either state institution or the department, so that we can be able to see that this money comes from the attorney, and the attorney is the one that was appointed in terms of corporate panel. Therefore, I think the next step now will be to give that executive the right of reply to say you received money from this attorney. What was the money for?
Oh, okay. No. So the reason I'm asking is because that bullet says SIU conducted a financial analysis, including back statements of the attorneys. I get that. You also then analyze the bank statements of the staff of the entity that you are investigating. Obviously, I'm trying to work out how you ascertain where this payment was going. So do you analyze only the attorneys, or you also look at the statements of the seeming recipient on the other side?
We out of the statement from the attorney, we will
Right,
see all the deposits that are being made. And if
right,
there's a name that we see and that is
right,
linked to RAF,
right.
then we are able to go back to RAF to say this individual is a member, it's an employee of RAF. How
Yes.
did they receive money from this? In most instances, we don't just make it. We analyze based on the allegation or the leads that take us to the person, and thereafter then we go to that particular individual so that we can also further to see that as you receive this money, where does it go? So the trail is we follow the money, and that's what lead us to able to get to the official.
Okay. No, no. Thank you, Mr. Lachet. I get that. So you see a payment that says SZB.
Yes.
Now there must be about 400 SZBs. What I'm trying to ascertain is, do you do further investigation to say this SZB is this one that works in Parliament? That's all I'm asking, because obviously your language is careful here, but I just need to get a sense of what this language means. Advocate Mutip.
Thank you, Honorable Chair, and thank you for giving me the opportunity here. Of course, Mr. Lekgeto and the investigators are the ones really that really can respond in terms of the evidence that pointed to us to say this in this slide. Honorable Chair, I'm really coming in because I am sort of the custodian of the investigating methodology, and I do, in so many words, in all the investigations, really implore the investigating teams to apply the methodology such that we are able to trace any monies that would have been received and that would have been received unduly from any of the service providers of the state institution and so on. So, and that is why, amongst others, we have capacitated our investigating teams with forensic accountants who are skilled at ensuring that they assess this. So in a sense, Honorable Chair, and I'm really glad that Mr. Lekgeto would have satisfied your question. Indeed, so the expectation from the investigators would be that they should do a very intensive financial profiling. We've got a methodology that we use to do a financial profiling, which amongst others looks at the call it exchange or movement of money from the service providers into any of the persons of interest. They could be employees of the state institution. So in this case, because the teams have briefed me on this investigation, it is exactly that they would have found that some of the attorneys who are on this corporate panel, would have observed that there's money moving from their accounts to individuals, and those individuals, of course, we checked, they would then have been REF executives, right? And as you correctly say, Chair, I mean, we need to go further. And this is what I instruct the investigators to do. We need to go further and establish the rationale for the receipt of this money.
I see.
And why is it that it landed in your account?
Okay.
And then from there, we can then make a conclusive finding that this money was, a receipt of corrupt activities or undue in this circumstances. So that's exactly what the teams are meant to do.
Okay.
And of course, they will be finalizing this aspect. As we say on the last bullet point there, that the investigation is ongoing. That slide that I presented, amongst others, the right of reply. So this, whoever is pointed to by the evidence will be given the right of reply so that we hear what their explanation is before we make the final finding. Thank you, Honorable
All
Chair.
right, thank you. Okay, no, I just wanted to establish that because there must be 100 Peter Smith, in one city alone.
Yes,
Thank
sir.
you. I get it.
Thank you, Honorable Chair. Mr. Lkhatho, you can proceed, sir.
Thank you, Advocate. Still under the corporate panel, and it appeared that within the service provider appointed by RAF, there was no fair rotation or allocation of work, as one service provider was allocated almost 90% of the work as opposed to other service providers. And we have noted that one of the executive who was possibly paid the money by the attorney might be using two identification numbers. But this one, the investigation is still ongoing, where we are ascertaining the two identity number that the individual had. And the SIU is finalizing evidence pack and DC, NPA, and civil litigation. Obviously, this will follow after we have done the right of reply to the affected individual so that he can clarify all the issues that we have found. And at this stage, there's a potential of recovery and there's also possible evidence of criminal referrals and possible DC referrals that we're going to be making after we have done the right of reply. Then the other contracts that we look at is...
Sorry, Mr. Lkhatho, forgive me. I'm going to ask for clarification again on the previous slide. So the preliminary finding is that one of the execs, so it begins with the money, and you then follow. So are you saying, is this on the basis that you've checked with Home Affairs or someone that the ID numbers belong to the same person? I thought it's not possible to have two ID numbers, or am I missing something? Is it under different names, or how does that work? What have you observed?
No, thanks, Chair. I think I'll ask the team to give the details on this one.
Sure.
Mr. Maseko, again.
No, thank you so much, Honorable Chair. What we have observed is that the name and the surname, they are the same, save for one letter that is spelled on the other identity number. So in the investigation, as we indicated, that it's still ongoing. We are ensuring that we liaise with the Home Affairs in terms of making sure that we get clarity insofar as the question that was raised by the chairperson. And we've got a proclamation with the Department of Home Affairs that we will send the 52A and ask in clarity in terms of that.
Okay. No, thanks, Mr. Maseko. So I don't want to compromise your investigation. I just need to get a little bit more. And this is purely because we have names that are very common in South Africa. Some people is Sipho with an H. The other one is Sipho without an H, or Sipho and that sort of. So this kind of thing happens. I'm just trying to understand what gave you the belief that you could be dealing with the same person.
Thank you. Thank you so much, Honorable Chair. The investigation goes over and above the issue of the identification, because we also look at the businesses that the person of interest may be attached to. So that will give the investigation an indication of the modus operandi. And without going into details, we will also look into that. So we will have a prima facie a case or a suspicion that the identity may belong to the particular individual, the 2 identities, based on also the analysis that were done on the companies that are linked to a particular individual.
Okay, all right. Okay, so there is an extensive examination of other records, or there is an examination of other records. So in other words, you'd go to CIPC and so on, and then I guess have a reasonable suspicion. Are you able to have you as yet spoken to the person about this possibility or not?
Honorable Chairperson, not as yet.
Okay. All right. Look, okay, I mean, continue, we'll come back to this. I just want to, and I'm being careful here not to make you reveal too much. I just want us to kind of especially on this one, get to a point where we just have a good sense of how you tie the 2 ID numbers to one person, that actually this is one person. But we can move on for now. I've taken a note. At question time, we can come back to it.
Now, thank you, Honorable Chair. The next one is the claim backlog contract, and the project was the allegation, it is alleged that the contract was awarded irregularly or unlawfully, and the project was established to reduce the RAF claim backlog totaling 37,000 with an estimated rand value of 2 billion, an estimated total handling cost of 742 million. The RAF spent an amount of 312 million and 530 million for travel and accommodation for the duration of the contract. RAF changed the criteria for files to be outsourced and recommended that the file selection should not be limited to only claims contained in the backlog data. This meant that all files were considered irrespective of date of lodgement, including newly lodged claims, as this dramatically increased the pool of files available for outsourcing. Then the RAF intended to appoint 3 service providers for subsequently appointed 2 service providers who were deemed responsive. And during the bid evaluation process, the BEC member had no standard evaluation criteria set out, and the mandatory and functional criteria advertised were not clear on how scoring will be allocated, and the evaluation criteria on functionality by RAF in the bid documents only provided for weight but not value. Despite this, value were used during the evaluation process. The SIU interviewed the role player, and it appeared that they were unsure on how the scoring on the functionality or technical criteria should be evaluated, and they had to constantly have discussion as members to ensure that the evaluation are on the same page. The SIU views this evaluation as not objective, since there was no clear distinction with regard to the scoring metrics. The functionality criteria was in contravention of the preferential procurement regulation, as it did not have values. The SIU found that the awards to be irregular due to non-compliance with Section 217 of the Constitution and the PFMA and the preferential procurement regulation. There were also issues of performance in relation to the contract, as one of the service provider was given 2,472 files and had only successfully completed 96 of those files. There's somebody talking. What? Chair, there's somebody disturbing.
Okay, that's fine. He's muted.
All right. One of the contract was awarded to a consortium, whereof one member of the consortium fell off during the contract, and the RAF internal audit conducted a verification on the BBBEE and not full legal standing of the consortium, meaning that if it's a consortium and it tendered, but during the contracting process, one of the members fell off the consortium, that means now the consortium is not fully represented, of which at that particular time, they should have been disqualified because they were not forming the alleged consortium at that point. There's a potential recovery, and the quantification is also being finalized for the evidence pack and NPA to be determined, and there's a possible disciplinary referrals, and currently we are providing the right of reply to the affected individual. Then RAF, with regard to the office building, the RAF advertised the office building tender, and the specification of this tender had the lease period for 9 years, 11 months, that is the long-term lease. Prior to the advertisement of this tender, RAF went to the market for at least 6 times, and it was indicated that RAF could not find a bidder that met the tender specification. It was through this tender that the RAF BEC recommended a successful bidder to the BAC, and it appears that there was an intervention by RAF management that caused this tender to be cancelled. The intervention of the RAF is thus summarized as follows. The RAF was not in agreement or in favor of the 9-year, 11-month lease. Instead, they wanted a 5-year lease agreement, and there was a decision for RAF to deviate from normal procurement process to appoint a service provider for an office space for a period of 5 years, subject to National Treasury support. And RAF executive instructed the newly appointed senior official to scrutinize the evaluation made by the BEC under that tender. So what it means is that the newly appointed senior official indicated that she found irregularity in the evaluation. I was trying to indicate, to explain that what happened is that the evaluation happened in this particular tender. And as a result, because the RAF management felt that they did not approve the 9-year, 11-month contract, they felt that this tender could not go through. By that particular time, the BAC had already recommended that this particular service provider must be appointed. As a result, the RAF management asked the newly appointed senior official to say, scrutinize and see whether you can see any irregularities in this evaluation. That's why now it says the newly appointed senior official indicated that she found the irregularity in the evaluation, and such irregularities were not reduced in writing. It was not written anywhere that we have found irregularities that will enable us to to disqualify this particular bidder. And this irregularity appeared to be the basis for the RAF to call for the cancellation of the tender. BAC approved the cancellation of the bid and supported the deviation process. The deviation process ensued, and RAF omitted to disclose material facts relating to the BEC recommendation of the successful bidder when they made a request to National Treasury to grant the RAF permission to deviate from the normal procurement process to appoint a service provider for the Johannesburg Regional Office Building. In the motivation to National Treasury, the RAF indicated that they will save costs, which also appeared to be a misrepresentation, as the cost implications submitted to National Treasury omitted the critical components such as parking, storage, maintenance, electricity, water, sewage, and diesel for the generator. National Treasury appeared to have approved the request by RAF to deviate based on misrepresentation by RAF. The RAF entered into a lease agreement for a period of 5 years at an estimated amount of 11 million at an escalation of 6% per annum. The action of RAF find no expression in the RAF SCM policy and procedure applicable at the time nor on any procurement prescript. In essence, the action of RAF are tantamount to overturning the decision of the BEC, which is at odds with the legal prescript. Noteworthy to make mention that the reason advanced by RAF in a memo to National Treasury did not stipulate the irregularities found by the RAF appointed official. Furthermore, the National Treasury was not appraised regarding the process undertaken to uncover the said irregularities. Financial preliminary findings to date, RAF has paid a total amount of 66 million for the Johannesburg Regional Office building. It is imperative to note that the amount presented to National Treasury by RAF is limited to rental expenses. The submission made by RAF to National Treasury, which indicated that RAF will save costs, appear to be a misrepresentation, as the cost implications submitted to National Treasury did not include those components that I've indicated. There are periods within which utility payments were not levied to RAF, and the service provider will then do a bulk charge. In terms of the outcome, there's a potential recovery, and there are 7 potential disciplinary referrals to be made, and SIU is currently providing the person of interest with the right of reply in terms of this office building lease. Then the other tender that we investigated is the fleet tender, where it is alleged that an appointed service provider failed to deliver vehicle as per the SLA. This was a sale and leaseback contract and was agreed that the awarded service provider should provide RAF the sum of 5.2 million for a transfer of 56 vehicles, which were belonging to RAF at the time, with additional car belonging to the service provider. The RAF delayed signing the SLA for over a year after it was awarded, which resulted in the service provider disputing the total value of the award. The service provider provided RAF with a revised offer of 3.1 million from 5.2 million, as the vehicle has depreciated in value, and RAF delayed in accepting the offer, and at the time of acceptance, the service that RAF transferred the ownership of 50 vehicles to the service provider, and the service provider indicated that the offer was no longer valid. The service provider offered to dispose the vehicle through an auction platform. That is those vehicles that were given to them, the 56 vehicles. The remainder of the 6 vehicles are said to be involved in accident and thus could not be transferred to the service provider. And the SIU further established that the contract should not have been awarded to the service provider, as the bid price of the service provider was exclusive of VAT and provided the service provider with an unfair advantage when they evaluated looking at other service provider. The successful bidder did not include VAT. Therefore, his price looked less. Therefore, when you include VAT, it means that his prices went higher. So that's why we say it gave him unfair advantage to others. The SIU is making necessary referral on this, whereby currently we are giving the person of interest the right of reply, those that were involved in this particular tender process. Then cleaning and security services, where it is alleged that RAF awarded an expired tender for cleaning and security service. The 5-year cleaning contract was for 4 RAF offices for a period of from 3 April 2017 until 2 April 2022 for an amount of 12.1 million. There was an escalation of 6% on original bid amount, which was 12.1 million. That resulted in the contract increasing from 12.1 million to 13.5 million. Contract variation and expansion. The contract was further extended on the 16th of March 2022 by RAF on contract value 257,000. And on the 1st of April 2022, a 1-month extension to the value of 361 was approved. And on May 2022, the appointment of the same service provider was made through RFQ to the value of 987, covering from May 2022 to February 2023. And on 30 July 2022, it was extended. On the other one was for 24.4 from 1 to 31 July 2022. The combined variation were within the required threshold of 15%. This is just explaining the variation order that went on in this particular cleaning and security service contract. Then a 7-month overlapping contract for Block A, Eco-Glade, which was valued at 171 million, commenced on the 1st of December 2021, but was only approved on April 2022, over 4 months into the implementation, meaning that it was only approved 4 months after it has already been implemented. A 9-month cleaning contract for RAF main lane, valued at 985, began on the 16 May 2022 to 15 February 2023. And the other 1-month extension contract for Block A in July 2022 overlap with the 9-month main lane contract. So when we look at the possible administrative inconsistencies which we have noted out of this, contracts implemented prior to approval, as indicated there, that the contract has already been implemented before it was approved. Variations were due to poor planning, and there was overlapping contract period for similar services, and there was possible splitting to avoid competitive bidding processes, and ability of specification amendment to accommodate service providers. We have identified that it existed within the whole procurement process. Then summary of contract amount, that is including the 12% variation. Following the expiry of the original 5-year contract, which was valued at 13.5 million, the RAF awarded additional contract to the service provider totaling 1.9 million, VAT inclusive. These were not subjected to open competitive bidding, despite National Treasury instruction note requiring an open tender for procurement exceeding 1 million. The absence of documents confirming adherence to this requirement, combined with fragmented and overlapping short-term contract, may suggest serious non-compliance. This may undermine key principle of fairness, transparency, and cost effectiveness, that is Section 217 of the Constitution and the PFMA Act. Then still under the security quotation being same amount, possible procurement fraud and tender irregularity, and on possible 3 separate occasions, the service provider submitted quotation that exactly matched the RAF estimated contract value. And this repeated pattern suggests possible pre-alignment or insider knowledge of internal cost estimate, raising serious concern about fairness and transparent and competitiveness of the procurement process. And on this one also, there's a potential of recovery, and the matter is ongoing where there's evidence pointing to criminality, and this will be referred to the NPA. And also on this aspect, we are giving the affected individual the right of reply before we can finalize this investigation. And the next one is the sub-license contract, where it's alleged that RAF procured the SAP Human Capital Performance Management licenses, which the RAF is not using, to the value of 1.8 million. The preliminary findings indicate that RAF is not using the said sub-license, thus this amount to fruitless and wasteful expenditure. This is a single source procurement, which is a direct purchase. And the reason and decision to purchase these licenses fall within the office of the RAF CEO. And the SIU met with the RAF ICT member, and he explained that the license in question was never utilized, as it is not what the end user requested. The sentiment was shared by the RAF CEO in his interview with the SIU. The end user was unable to use the product as it was not fit for the business purpose. The view of RAF ICT is that it is better to reduce the cost and optimize discount by consolidating the procured license for one service provider. The SIU is referring the matter to the special tribunal for the cancellation of the contract and for the costs related to the license. In terms of the office furniture, it is alleged that an internal audit report indicating that 36 million office furniture contract escalated to 40 million irregularly. And also the legal opinion from internal legal department indicated that the amendment of the service provider agreement, which escalated the cost, was irregular and invalid. The finding is that the appointment of the service provider appeared to be irregular, and the reason for the escalation potentially fall within the outside of the prescript, and the amendment of the SPA appeared to be irregular. And on this one, there's a potential of the recovery, and there's also the potential of criminal referrals to the National Prosecuting Authority, and there's a possibly DC referrals, whereby currently we have given the affected person the right of reply, and after we receive the response, then we will be making a decision as to whether do we proceed with the disciplinary referrals or not. So that is done with the procurement process within RFA. In terms of now, we are looking at the duplicate claims payments made to attorneys, claimants, and sheriff, and change of mandate. The investigation focused on the loss incurred by state caused by duplicate payments made to several firms of attorney, and the duplicate payments were allegedly affected by the sheriff who executed upon rates of execution and received funds on behalf of the instructing attorney. The RAF has a payment system which dictates that when a claims offer is accepted, whether the settlement or by way of court order, such claim will wait 180 days before it is paid. As a result, the attorney will then attach the RAF bank accounts by way of rates of execution served by the sheriff, causing RAF bank to effect payments in terms of the rates upon the 180 days lapsing, the same claim will be paid against, thus constituting duplicate payments. In explaining it, Chair, the settlement will be signed by either issued by the court. Then RAF will put that settlement, the payments, into their system, whereby the system will pay after 180 days. Then the attorney, instead of waiting for 180 days, they will go to court and to get a default judgment against RAF, whereby the accounts of RAF will be seized, and whereby the attorney now will receive the money immediately, not waiting for the 180 days. And when 180 days come, because the payment has already been loaded in the system that it should be paid after 180 days, the payment will be effected to the same attorney who have already been paid after attaching the bank account of RAF. That's why now there's a duplicate payment, because the payment has been made by attaching the bank account, and again the payment is made by the system as it was in time that it should pay after 180 days. So the SIU is investigated actually 102 law firms who received duplicate payments from RAF to the value of 340 million. When approached with evidence, that is those attorneys, several legal practitioners have opted to cooperate with the SIU in defrayal of their indebtedness by signing acknowledgement of debt from the approximately an amount of 340 million. The RAF and SIU have managed to recover some of the funds. To date, the SIU has signed an AOD to the value of 70.9 million, with actual cash recovery to date amounting to 42.5 million. And the SIU revealed that the total amount of 279 million was paid directly to RAF by legal practitioner, and the SIU investigating whether such instances there were possible misappropriation of funds. And this happened because as we approached some of the legal practitioners, they decided to pay the money directly to RAF rather than pay it to SIU. So as a result, we want to check whether these payments, how was it made? Was it made from the trust account where the money was deposited, or the money was paid from any other source? Then based on the above, it therefore means of the 340 million, an amount of 317 has already been recovered. The investigation into the focus area is complete. The SIU is currently rendering litigation support and computing interest on the amount recovered. The report is drafted and being subjected to the SIU governance structure for review on this aspect. And as at 10 February 2025, the SIU paid 31.2 million to RAF from the money that we have recovered out of the signed AOD. And the SIU civil litigation is currently considering pursuing legal action against the law firm failing to honor the sum of those signed AOD. And in the duplicate payments made, as alluded above, the SIU found evidence pointing to criminality wherein trust account money was misappropriated. And this we have found because the money that was paid back to RAF was paid from different accounts. And it clearly shows that the money which was there was misappropriated. As a result, the attorney went and obtained money from somewhere else that they can able to pay back those duplicate payments. And among those are the law firms which have signed the AOD, because if they sign AOD, it means the money that they've received, they've utilized it, and they could not have utilized the duplicate payment, of which it was not money that was not supposed to have been paid for them. So therefore, all those firms that have signed the the AOD, it means they've misappropriated the trust account money. And there are other law firms who have since refunded the duplicate payment directly to RAF. However, the proof of payment submitted to SIU depict that such payments were made either from lending institution other than the trust account, meaning that the money was not there. They received money from somewhere else in order to pay back RAF. The SIU has referred evidence which points to the commission of an offense against 12 law firms or legal practitioner to National Prosecuting Authority, and the referrals are currently with the DPCI for further investigation. And SIU found that there were attorneys who received duplicate payments and have since been struck off from the roll. They have been suspended and others have passed away. And SIU is working with LPC appointed curator bodies to recover the money. Reconciliation is done periodically on the legal costs due and payable to the suspended and struck off practitioner and the deceased practitioner in order to recover the money due to RAF. Wherever there's evidence of misappropriation of trust funds by practitioner, referrals have been made to LPC to take appropriate action. And to date, 5 practitioners have been referred to the LPC, and change of mandate by claimants on the implicated practitioner is handled by the appointed LPC curator bodies. An update were provided to SIU by LPC. There is one matter before LPC wherein there is a dispute regarding the quantum, that is 2 million different, and the SIU, LPC, and RAF met in order to resolve this impasse. In terms of still duplicate payments, I think we have already summarized it. We can go on. The next one is dealing with the block payments, which is slide 44, where the SIU previously reported on a blocked payment to the value of 482 million for attorney due for payment by reason of the RAF internal investigation. In relation to the above an amount, the SIU noted that the matter marked by RAF Treasury as blocked due to RAF internal investigation were incorrect. What it means is that some of the claim will come in as a result, instead of the payments being made to the attorney, then RAF will block the payments and indicate to the attorney that we are not paying you because there's internal investigation that is ongoing. So this is what does block payments mean. There are instances where a law firm will be investigated by RAF for bill of cost, and RAF Treasury will block all matters related to that law firm, thus prejudicing the claim. These block amounts are accumulating interest which RAF will be liable for, and this may have implication on their financial statement. The SIU, in line with the investigation relating to the payment to service provider in terms of the RAF Act, will also establish any possible prejudice to claimants due to unwarranted delay in payment. So the other focus area, we looked at the payments made to service provider in terms of the RAF Act and/or contract. The focus area involved 3 payments made to 9 service providers by RAF in terms of their act. RAF pays claims from service provider who have rendered service to the victim of motor vehicle accident. This claim include inter alia, ambulance claim, hospital claims, and doctor claims, and other experts who will have provided service to the members that is affected. The above payments are part of the ongoing investigation informed by payments analysis to be concluded in October. Currently, we are analyzing all those payments that has been paid by RAF so that we can see whether they were paid regularly to the service provider that will have rendered service to RAF. The other one that we look at is the fraudulent claims. On this one, it's alleged that there was an attempt to change bank accounts of the service provider. RAS received internal intelligence reports relating to the attempt to change bank accounts of the service provider. Upon investigation, SIU established that the RAF employee have made a bank fraudulent account changes on the RAF system and redirected money meant for the service provider into their personal bank account. The amount found to date regarding the personal account of this employee is 1.9 million, and a substantial amount of the 1.9 million was used to purchase traveler's check. The SIU has made the NPA referrals regarding the person of interest, and the traveler's check cannot be traced as the bank that issued them no longer does so, and there is no historical data when we look at the traveler's check. The SIU is following the money depicted on the persons of interest bank account, and the SIU noted that the person of interest used salary as a reference in the bank account, and such salary ranges from 60,000 and below, occurring every 2 months to 3 months. And on this aspect, as indicated, we have referred the matter to the NPA, and there's a potential recovery, and there's possible DC referrals where we're currently looking at it, and we are giving the person that is implicated the right of reply. Still under fraudulent claims, it is alleged that there is a fraudulent claim submitted and paid by RAF. The investigation covers all the provinces in the RSAA. So this one involves all the claims that are submitted by legal practitioner to RAF, and the investigation cover both foreign and national claims that are submitted, and they also involve claim for modification across the entire Republic and the repudiated claims. So those are the claims, all the claims that we are looking at. And progress on this aspect, the SIU has completed mirror image of RAF claim systems where red flags have been identified by data analytics, and investigation has commenced in various provinces. This one is a massive investigation where we are looking at all the claims that have been submitted so that we can identify the fraudulent one where either there was no accident or where there was a request that a person's house must be modified so that it can able to accommodate the person that was injured out of the accident. It's then you find that there was no modification which was done, but there was a claim which was submitted to RAF. So we have identified some of those red flags where we are currently looking at them, and the investigation is ongoing on that one, and there is no outcome at this stage. Then the out of scope matters, we have identified that there were other matters which were out of scope, and these are the allegations that we have received that the RAF appointed some RAF executive without following the due employment processes and without vetting the executive. Amongst the appointed executive, there is an executive who is alleged to have absconded while facing 12 counts of serious financial misconduct at the City of Johannesburg municipality. And there's also further allegation against executive and managers who were previously working with the RAF CEO, and that their employment at the RAF did not follow the due employment process. That is, the people were appointed without following the process. And summary of general observation. These are the observations that we have made, that RAF claim system has many modules, and thus SIU IT experts are working to ensuring the integrity of data to ensure accuracy is not compromised. And there is an influx of rates of execution attaching the RAF bank accounts while the said claim is already loaded on the RAF payment process. This is the one that is leading to the duplicate payments. And the foregoing observation also revealed a lack of delay in reconciling the RAF bank accounts against the claim paid under the normal payment process and the rates payment. And the RAF employee who are key to the investigation are no longer in the employment of RAF. And RAF had 3 instances of ransomware attacks that occurred during December 2020 and 2021 and August 2021. Thus, some of the information relevant to the investigation was lost, and at this stage, the impact is minimal, but the SIU investigation is ongoing, and the impact will be monitored as the investigation is ongoing. The SIU notes the high risk of litigation, particularly from the person of interest. And as we know that the RAF environment is very litigious, and there are instances where RAF block attorneys without just reason to do so. And the red flagging of one claim affected all claims regarding the block attorney. This one explained whereby the one attorney will be blocked because the RAF is investigating the payments, particular to that blocked payment. As a result, they block all the payments, irrespective whether they are under investigation or not. Just because they are investigating one claim, as a result, they block the entire claim of that individual attorneys. The RAF has a tendency of not deleting user profile upon termination, which results in those profiles being used to commit fraud. Documents management at RAF remained a concern. The impact of not paying claims to victims is accumulating the interest, and unjustified healthy cash flow in some instances can worsen the socio-economic circumstances of the victim. That is, by not paying claims, we are worsening the socio-economic circumstances of the victim. And the impact of not defending claims is attracting unnecessary default judgment, and unwarranted claims might be processed and being paid. So the interest also is accumulating by not paying some of those claims. And the systemic recommendation, as previously reported, these are the one that we've previously reported, that the SIU emphasizes that this systemic recommendation made since our last COPA engagement has not received attention, whether some will be implemented or not, like the one of periodic bank reconciliation in order to prevent and detect possible duplicate payments, and also the prior to effecting payments, they need to perform check and balances on whether there had been any rates of execution regarding the claim that they are paying, and also to review the claim payment process. So we have not received any response whether some of this systemic recommendation has been implemented. Then coming to the summary of the outcome, actual cash recovered, 317 million, potential disciplinary referrals where we are waiting for the right of reply. And once we got that, we'll be able to make assessment. And after the assessment, we'll decide whether we refer disciplinary. And we've got 20 of those instances. And NPA referrals, we have referred 20 referrals to NPA. That will include officials, the legal practitioners, or the service provider. And administrative referrals, that is SARS, blacklisting, CIDB, LPC. We have referred 5 LPC referrals for the legal practitioners so that action can be taken against them. And so far, we have referred 2 presidential reports in relation to this investigation. That is the end of the investigation. Thank you, Honorable Chair.
Thank you, Mr. Lekgetho. Honorable
think
Chair.
he meant that is the end of the presentation. He said that's the end of the investigation. Did you notice?
Mr. Lafetto, please. We, we indicated to the Honorable Committee that the investigation is still ongoing. Honorable Chair, thank you for that observation. Mr. Lekgetho, Honorable Chair, that's our presentation. There's just two corrections I want to make. Mr. Lekgetho, if you can go to slide 13, please. And I'm just doing this, Honorable Chair, just so that the recording can read the same as the presentation. On slide number 13, on slide number 13, Mr. Lekgetho read that the memorandum of agreement between REF and Solicitor General was signed. The presentation reads unsigned. If the recording will read that it was signed and conflict with the presentation. Another correction.
Sorry, then what is the actual status? Is it signed or unsigned?
It's unsigned according to the presentation.
All right.
Yes.
Okay, so the accurate state of affairs is that it's unsigned.
That's right.
Okay, all right.
It's a very important connotation that if it remained unsigned, there's as I say, there's particular connotation on that. Slide number 17, I think Mr. Lekgetho said 1 million instead of 10 million. The CEO can approve any contract up to 10 million. My colleague said 1 million. So I need to just make sure that the recording will read the same as the presentation. Honorable Chair, that is it from our side. Thank you very much.
Thank you very much, Advocate Motibi. So I am cognizant of the fact that you guys have been speaking for, especially Mr. Lekgetho for nearly 2 hours. And also the members might also want to take a body break. Can I just ask members, the time is 10:44. May I please ask that we return at 11? So we'll take a 15-minute break and then return at 11, and then we'll go straight to questions. Thanks very much.
Honorable members, good morning once more.
Welcome back. So I just want to be sure that you can hear me.
Can hear you, Chair.
Yes, Chair, I can hear.
Thank you very much, honorable members. So I'm just going to make a comment so far, and that is, I think one of the issues that we canvassed twice with the road accident fund was the issue of vetting. I think we dealt with it in February, we dealt with it in April, and looking at this report for me, it deepens my concern. And I did, particularly personally, to the chief executive, implore him to make certain that that people are adequately vetted at the institution, because it deals with money, with lots of money, and it is risky to not have people being adequately vetted. One of the issues we had canvassed then, we'll provide the correspondence to the committee. One of the issues that canvassed then was in respect of the chief investment officer who had been at the City of Johannesburg, and the RAF couldn't tell this committee whether that person had been found innocent or not. The Secretariat sent a letter from me to the City of Johannesburg asking for clarity on what had happened. And as it happens, the person was actually not found guilty. The charges were not dropped because there was no case against them. They were dropped because they opted to leave the organization, and therefore, as a person was no longer an employee, they were left with no choice but to drop the charges because they could not discipline the person. That response only came in yesterday. We had asked a long time ago. It's taken many follow-ups. Now, the committee should not have to do this on its own for any institution. The institution, as part of the recruitment process, should be able to make those inquiries before engaging people. And that was part of my concern in my at least exchange with the CEO, to say, please, let's get the vetting done, because if we don't vet people, it's a problem. In February, the chairperson of the board had said that people in acting roles do not get vetted. And there was an exchange again between myself and the chairperson of the board to ask the purpose of the vetting, because it's got nothing to do with permanence. It's got to do with the role and the signing powers that they have and the decisions they take. So I think that the allegations contained herein are worrisome in that context, because some of these things are preventable if institutions take the necessary care to make sure that the people they employ in senior positions should be in those senior positions. And this committee has been consistent at Eskom, at Transnet, at PRASA. It comes up each and every time. So anyway, so that's what for me is at a fundamental level. I know there are allegations around it, but I sit and think it could have been avoided. It really could have been avoided if what needed to be done by way of the recruitment process had been done. I will give the members, you members, an opportunity to ask questions and see what is left of the questions, and then ask my own if they have not yet been addressed. So I'm just going to note the hands. Please forgive me. I will also do some note taking myself, so I'm not doing other things. I just want to be certain that I note the hands properly. So I see two so far. I see Honorable Atkinson, Honorable Beasley. So I see four. So we'll take these four for now. So Honorable Atkinson, then it will be Honorable Beasley, then it will be Honorable Neil May, and then it will be Honorable Skosana D. Okay, so Honorable Atkinson, Honorable Beasley, Honorable Neil May, and Honorable Skosana D. Thank you. So let's go forward in that order.
Thank you very much, Chair. Chair, and just a continuation on your point of correct vetting. There still seems to be a little bit of a question mark around whether or not the CEO actually received a security clearance. I know you've asked that question. I know the Minister undertook to clarify that and ensure that it is correct. And if I could ask the members of the SIU, please, to make it a point of urgency to find that out. And the reason why I say that is that if the CEO actually doesn't have a security clearance, it actually renders almost all of his decisions and everything he signed off null and void, because then he's actually hasn't been properly appointed. So I do think it's critical that we actually get that particular issue sorted out. The second thing, and it actually, I want to thank the SIU for the presentation today. And I mean, it really is quite shocking in a sense, the level of suppose wrongdoing in a sense when we look and see what has happened in the fund and the amount of public money that's been wasted. And we thank you for highlighting that and actually for quantifying it as well, because we are particularly interested in quantifying the losses associated with not actually having a proper board of attorneys to be able to defend each of those actions, each of those judgments that were brought against the Road Accident Fund. And I'd like to refer the advocate to our presentation on, I think it was on Wednesday, where we spoke about the SABC and the actions you're taking to get money back from Mr. Motsoeneng and other members of the SABC, and how you actually went after members of the board as well, where there was financial loss and there was additional money to be recovered that members of the board had become liable. So my question is, because of the huge loss actually suffered by the Road Accident Fund, by not having a proper panel of attorneys in place, and by the board allowing that to happen, would it not be proper in the same light then to be taking actions for financial recoveries against senior executives of RAF and also members of the board? Should they not then become liable for those losses that were incorrectly affected by the Road Accident Fund? And in essence, it all comes back again to the members of the public, because we, the people, through our taxes, we have to fund the fund. So what I'm asking is, would you be able to bring a similar action against the members of the board of the Road Accident Fund as you did with the SABC? And then the third point, which actually didn't appear in today's presentation, was this issue surrounding the call center at the Road Accident Fund. So there have been a lot of questions out there about the appropriation for it, where the money has been found. It hasn't appeared anywhere in financial statements, because I think it's a more recent action, but there are some very big questions around what is actually a lot of money being spent on the call center, about whether it's actually even really needed in any way. So if I could ask maybe that the SIU take a look at that, because I do think there's been quite a lot of potential for fraud within that tender. And I think it would be of great value to people if you maybe could cast your eye on that and do a little bit of investigation on that as well. And then my fourth and final point was on the issue around duplicate payments. So you said in the presentation that a number of law firms actually agreed to cooperate with you, and you were able to get a lot of that money back. Did you pick up any instances of fraud where duplicate payments were made and then people in RAF or externally were paid money out of that? So in other words, they helped to facilitate those duplicate payments. Were they just errors, or was there fraud and corruption involved in that? And was that something that you were able to find out from the people that those duplicate payments were made to? Did they cooperate with you to the extent that you were able to find out that information as well? Those are my questions, and again, thank you to the SIU and everything for what you do for us as well. Thank you.
Thanks, Honorable Atkinson. So I can deal with the first one, because the Road Accident Fund presented to us last time. So there is not a single executive at the Road Accident Fund who has been vetted yet. All of them are in process, from the chief executive on down. And we don't know when that vetting process will complete. So if that's helpful, Honorable Atkinson. So they gave us the
Thank you, Chair.
They gave us
Yeah.
information, and no one has been vetted. The process is, the vetting is only taking place now. All right. Honorable Beasley.
Thank you, Chair, and good day to the SIU and to my colleagues. So just to put into context, Chair, the Road Accident Fund has an annual revenue of 50 billion. I mean, it is enormous, and just to see the scale of the corruption and wrongdoing and malfeasances that's going on, it breaks one's heart. I mean, and 50 billion annual revenue, it's massive. I mean, the internal controls and everything in this organization should be so tight that nothing like this can actually happen. And last couple of days, we've been haggling over a VAT of 13 billion. This organization collects 50 billion a year and comes from, hard-pressed South Africans. So I just want to find out from the SIU, when did they actually start this investigation? And in that time, how many people have been actually criminally charged and disciplinary processes have actually been held? So how many people have been actually criminally charged and disciplinary processes been held? And how can we actually speed that process up? Because, I mean, the AG keeps on saying that we got to bring accountability back in the system. But if accountability takes too long to happen or not at all, we're never going to get our hands on this corruption and incompetence that's taking place. So how can we practically speed up the process of getting people criminally charged and disciplinary process actually happening? And then just reading through the reports, it sounds like most of the executives seem to be implicated. I don't know how many executives there are, but executives were used quite a lot. I mean, what comfort do we have that any disciplinary processes would be independent? Because to have a disciplinary process held by somebody who's compromised himself, it doesn't talk to independence at all. And then have lifestyle audits been done on the executives? And then what I find very interesting in your systemic, or I don't know if I'm saying that word right, recommendations, is that periodic bank reconciliations need to be done. In my auditing days, 101 is that a bank recon has to be done the first day after the end of the month. So I'd find it absolutely bizarre and outrageous and incomprehensible that the RAF, he's got an annual turnover of 50 billion revenue from hard-pressed South Africans aren't doing bank reconciliations. To me, that should be absurd. And if that is the case, they should all be fired. Thank you, Chair.
Thanks, Honorable Beasley. Honorable Neil May.
Good morning, Chairperson. Good morning to the advocate and your team from SIU. Good morning to my colleagues. Chairperson, a lot is of a comment and one or two questions. And I would like to commend the SIU for the critical work that it continues to do in upholding the principles of transparency, accountability, and integrity within our institutions. And of course, their unwavering commitment to maintaining the independence, particularly in investigations concerning non-compliance, double payments to legal service providers, and fruitless and wasteful expenditure. I mean, it's vital to safeguarding public funds and restoring institutional credibility. Chair, one of the things that I like to support is in the innovative way in which they looked at the letter of engagement over the memorandum of understanding. And I think as that enhances legal clarity and ensures the SIU's operational autonomy, which then will be preserved. However, I must raise a few serious concerns with regards to that seems to be compromising the integrity of the investigations. And that was particularly the instructions reportedly issued to RAF employees, directing them to submit their right of reply via management rather directly to the SIU. Chair, this practice undermines investigative transparency and risks creating a culture of fear or censorship that could obstruct the flow of vital information. And I'm wondering if there's something that we in future can also sort of assist in making sure that there are clear channels that information needs to go directly to the SIU. Additionally, Chair, what has come to light, which I think was what we have seen here, is the contract management has blatantly been flouted. And I think obviously there's a culture of non-compliance. I think we've seen it across all the institutions that we have had to oversee. Of particular concern is that procurement of the ICT software package and licensing, reportedly initiated under the directive of the CEO, and which was never implemented due to being unsuitable. This not only constitutes fruitless and wasteful expenditure, but raises flags regarding the procurement planning. But there was a comment that came out of the presentation with regards to, and I'm not sure if it was a cyber attack or what attack that was, where the RAF lost information, and that information cannot be recovered. So I'd just like some clarity on that. The chairperson, just finally, of interest to me is the monies received unduly paid directly to individuals at RAF, and would be interested to eventually see their right of reply, because this is a culture of wholesale looting, because no one will pay without receiving something from the RAF. So obviously, you know, I give you this contract, we work this system out, and obviously they would get something, you know, through the back door. You've mentioned, and I'm not going to speak again about the appointments of the executive from the City of Joburg and the vetting, so that you have clarified. The use, yes, Chair, the use of not adding VAT or disclosing VAT on contracts is like putting the wool over one's eyes. Surely that's an old trick. I think, you know, service providers, when they look at different things, that has to be an old trick. And I'm surprised that National Treasury did not check that out before, because I think that is something that it's not new, if I can think back. And has the SIU checked all the correspondence to National Treasury in that line, so that one can actually see how they actually presented that contract? Chair, I think so far the other questions that my colleagues have mentioned, I'm happy with that. But it is, yes, here we go. The last question: honesty and integrity of the Sheriff's Office and attorneys. I think that really stands out to me, because surely the sheriff itself, the sheriffs themselves, must have realized that there are double payments with regards to that, and obviously attorneys, but then the attorneys themselves, like you say, I think that could have been something that was planned. They know the system, and they worked the system, and that is how they have been milking the RAF all these years. Thank you, Chair.
Sorry, I forgot to unmute myself. Thanks, Honorable Nell May. And then there was Honorable Skosana. I don't see your hand, but I'm supposing you put it down because I recognized you.
Yeah, I'm here, Chair.
Please go
do you
ahead.
hear me?
Please go ahead, Honorable
Thank you.
Member. Yes, I can hear you.
Thank you. And I just want to greet everyone here, the SIU, my colleagues and the staff. Indeed, we are back to the ref story again. It looks like it's a hot potato. Chair, I'm not sure whether am I correct by saying that, Chair? Is it a hot potato?
I thought PCM is.
Yeah, I'm a bit disappointed, Chair. You know, when there's an investigation and there's a casting of aspersion to other people to say apparently, you know, the specification was designed to fit a particular company. For me, we need to get facts, not this issue. Like we are back to Zondo Commission here, where the Secretary General of the ANC said, anyone who wants to urinate just goes to that commission, the State Capture Commission. We need to get facts here. Now, I'm going to start by saying, Chair, now, my question is, I've forgotten the name, when he said that apparently the limit for the CEO to sign was 10 million. Am I right, Chair? If I heard well, because I've got a problem here of a network. There's load shedding in Captain Park. But if I heard well, he says there's a limit of 10 million. If I remember well, you know, our researchers are doing a good job for us. They said that that limit was extended to 40 million. I'm not sure whether the SIU investigators are aware of that. That's number one. Number two, I want to find out again, because this matter is coming to us, because as there's a proclamation when the president issued proclamation, obviously they have to report back to him. To the SIU, did you discuss these allegations with the Road Accident Fund before coming to us? And is there any law, you know, that you can perhaps present to SCOPA before you brief the president? And is there any preliminary findings? And how is it processed to confirm the findings? Is it lawful to come to us as well to give preliminary findings without a preliminary report? Because I don't have. And what is the background as well of the SIU investigators, or perhaps the investigators themselves are? I want to you know, use the right word. When I'm asking that, I'm saying let me just be clear. What is the background of the SIU investigators? Are they lawyers? Have they practiced the ref law before? I hope I'm understood. Did you disclose that you are lawyers investigating road accident fund, or is it a secret? I just want to find out the evidence to support all the allegations we heard here. The issue of the sheriffs, the issue now of this issue of duplicate payments, it's a worrisome that some lawyers, as we speak today, have not paid back the money. And if I remember well, there was a minister as well, firm, which was involved, but I'm told they paid back the money. I'm going to ask those questions as well. In that, how many? It was I only saw 5, if I remember well, on the slides. I only saw 5 that indeed money. I mean, I'll say that if I remember well, there's 5 administration referrals by SARS, blacklisting, NCIDP, and LPC. My question is, when they had 5, how many were found? You know, that they were paid double. And these sheriffs as well, were they taken to account for this maleficence and this corruption which they committed? And these lawyers as well, who are hiding monies to the so-called trust account, how many of them are being blacklisted? How many of them are blacklisted? For them to say they pay back the money after they were chased, for me, that's not good enough. You know, for me, that's not good enough at all, because we are talking about some of the big law firms here, and they're making interest. Whilst they are sitting with it, it's over years now. They're making interest on that money. I'm not sure whether when the SIU chase them, when they recover the money, they pay that money with interest. That's my other question. My last one will be indeed, we need to get to this matter once and for all, because there's a big power play in this matter of ref. There's big players here who are wounded. But I must emphasize once again that it should not be viewed as if we are protecting ref, a CEO or the board of ref. The issue is that we must have facts here. You know, Discovery has lost a lot of money. They are not happy, and some lawyers are not happy. Some of them, as I said to you, who attend some of our meetings there, they're accusing us of defending ref. There's a lot of people have invested so much at ref that they are milking it. Now, if the CEO and his staff and his management can save us 24 billion rand, what more do we ask for? What do we ask for? Well, chase lizards. Why is there crocodiles here? There's many crocodiles. I mean, if one has to politicize this, I'll go to the VAT increase, which has now been withdrawn. But I don't want to go there. But I'm saying, if one has to look into this, let's get facts. The issue of apparently, it's for me, it's a lame excuse. Let's get facts. Thank you.
Thank you very much. I was going to say, please don't mention VAT. Some of us are traumatized, you know.
Thank you.
I can do without that word for a week. Okay, Honorable Matiwane, I can see you. So, and I said I'm gonna give, so you'll be in my batch, please. I said I'm gonna give the 4 members a chance. So you and I and others will be in the next batch. Can I give the SIU a chance to respond?
Well, thank you, Honorable Chair and honorable members. Starting off with questions by Honorable Atkinson. Chair, you've addressed the issue around the vetting. Now, regarding the board responsibility or accountability, once the standing instruction to the teams, and not just the teams investigating at RAF, and that's why we did that at SABC and the others, is that evidence of accountability or lack thereof has to be assessed at all levels. So if there's evidence pointing to the fact that the board was supposed to act and that it did not act, we will definitely make sure that the board is held to account. Of course, we'll follow due process like we following with all other individuals. Monies being spent on the call centers. Mr. Lekgetho, please, if you can just note this, whether the investigations are considering the call centers, and if so, please appraise the committee, please. Are there instances of fraud where officials were involved in facilitating duplicate payments? The same, Honorable Chair, if the COO can respond to that, because that is the function of evidence uncovered by the investigations. Honorable Beasley, how many have been criminally charged? At the moment, according to our referrals that we have summarized on slide 58, we have referred 20 matters to the NPA for consideration to prosecute. And there are also 20 referrals for disciplinary action to be instituted. We can go back and find out from the NPA and both on the disciplinary referrals what the status of these referrals are. In the normal run of our business, we do engage with NPA and finding out what is happening to the referrals made by SIU. Before this presentation, we had not gotten any feedback around the 20 referrals. We will do so, Honorable Chair, and return the response in writing to the Honorable Committee. So will we do with the disciplinary referrals. Honorable Neil May, thank you for the comments around upholding transparency. It is indeed one of our stated objectives that we should contribute to the transparency and accountability and consequence management where evidence points to that. Yes, the observations around the letter of engagement that we presented earlier was amongst others to ensure that we maintain our independence. The issue around cyber attack, I know we mentioned it in one of the slides, so Mr. Lekgetho, please note if you can respond to that, please. Monies received by employees, as we indicated, that as part of the investigation, we found evidence pointing to monies being paid to the employees' accounts, and further investigation is going on there, including the right of reply to those employees whom we have identified. The issue around service providers not disclosing the VAT, we've noted that, and is one of our observations in one of the service providers who did not disclose the VAT, and we found that it was really irregular. Yes, we do engage with the National Treasury in terms of verifying some of the processes, and we will continue to do that. The team has contact persons with National Treasury, in particular from the Chief Procurement Office, where all of this will be verified. The Sheriff's Office and attorneys should have realized that there's double payments. We agree with that, and that is why we have really confronted most of the attorneys and to ensure that we get the monies back. In terms of sheriffs themselves, perhaps Mr. Lekgetho and the team, you can indicate if we have made any referrals relating to the sheriffs, please. I've noted that. Right, Honorable Skosana, the other comments really I will not be in a better position to comment whether it's a hot potato. So what we agree with, what I totally agree with you, is that the committee, the honorable committee, needs facts and findings based on facts. As you would know, Honorable Skosana, is that, and we've said it before, our investigations are kicked off by allegations reported. And once we get the proclamation, we investigate so that we uncover evidence that indicates whether the allegations are substantiated or not. Once we get the evidence, we also look at the facts disclosed by the evidence. And what we do, we apply the law to the facts and come to the findings. And once we come to the findings, of course, if they are adverse against any individual or any entity, we do give them the right of reply and we finalize our finding. And once our findings are finalized, we then prepare the final report and, of course, the related referrals. Of course, the next steps for those who are implicated and referrals are made against them, they have got the right to take legal actions, and we have experienced that several times. We have gone to court to defend our findings. In instances where we have to cancel contracts, we do proceed to the special tribunal to get the contract cancelled. There are potentials in this investigation that we may proceed to the special tribunal to cancel several contracts. Of course, that is dependent on the right of reply that we will be granting to some of the persons implicated here. So we do agree with you. Now, did you discuss these findings with REF before we came here? As I presented, I said I received a formal request from the REF board chair to come and present to the board on our preliminary findings. There is no legal provision whether we have to present to the board first or we have to present to the committee first before we go to the board. There is no provision relating to that. The only legal provision in our statute is that we report directly to the president when the investigations are finalized. We also submit progress reports to the president. Now, the question whether it is lawful to come to this committee or not, I would indicate to Honorable Skosana that in terms of our legislation, we've got the responsibility to report to Parliament. There is clear reference to the Parliamentary Committee, the Portfolio Committee on Justice and Constitutional Development. However, Parliament as an institution operates by various committees, including the SCOPA. So it is our view that we are enjoined when Parliament calls, in particular in this case when SCOPA calls on us to come and present and update SCOPA on our investigations, that we have to respond. So that is our view. We see it as a duty on ourselves to report to Parliament. Of course, as we report, we will indicate where appropriate that we will not be able to, disclose certain facts or certain evidence or whatever the case may be. A typical example is that there's reference to persons of interest. Because the investigation is still ongoing, we cannot name those persons. And that is why we have qualified in all of these instances that the investigation is still ongoing. We are giving the individuals the right of reply before we finalize the preliminary findings. We're calling them preliminary findings for a reason, simply because they're not final. What is the background of SIU investigators? Honorable Skosana, when we first presented to this committee shortly after it was constituted, as part of the presentation, we indicated the skill sets that are in SIU. So we are satisfied. I am satisfied as the head of the Special Investigating Unit that the SIU has got the necessary skills that are required to investigate any form of allegation that forms within our mandate. We do have forensic lawyers We do have civil litigation lawyers. Most of our lawyers have been prosecutors, they've been attorneys, they've been advocates. So on that one, I can assure the Honorable Committee that we do have the skills as the Special Investigating Unit to investigate. And that is why we pride ourselves that we can compete with the private sector, and we can compete effectively. We are of the view that we do have the skills. Evidence to support the allegations. I think I've covered that. Some lawyers have not paid back the money. Indeed, that is why we have indicated that we are considering to take action for those lawyers that have not honored their acknowledgement of debt agreements. In terms of referrals to LPC and the other administrative referrals, there's 5 of them. So, Mr. Lekgetho, the question here is how many more, if any, are likely, and I use likely guardedly, to be referred. So if you can, or at least those that are still under investigation, if you can please appraise the Honorable Committee, Honorable Skosana, on that. Do lawyers pay the money with interest? I recall discussing this with the team. Our preference, of course, is that they should pay the monies with interest, but I don't want to mislead the committee, Mr. Lekgetho. Please indicate that when we pursue this payments, do we also pursue interest? There's power play here. I don't think I'm qualified to respond to that. Honorable Chair, the issue of apparently is not a lame excuse. I think we've used the terminology that it appears. It does appear from the evidence that we have found, and it's subject to final verification through the process of right of reply and so on. So we believe that's the appropriate terminology to use. Honorable Chair, that's where I leave it. Mr. Lekgetho, I've mentioned a few that please you need to come in. If you can come in, please.
Thanks, Advocate, and thanks, Honorable Chair and Honorable Member. I've noted some of the matters where I need to give explanation. The issue about the call center, we have not received allegation on that aspect. Therefore, it means we are not investigating that aspect. But the request is for the Honorable Member to forward to us the documents that we can able to pack together with other matters. I've presented other matters that are out of scope. So we can look at it together with all other matters that are out of scope so that we can see whether we can motivate for the extension of the proclamation or to get a new proclamation. But we'll take any allegation that can come. And on the issue of the issue about whether the payments, the duplicate, was it an error or not? From our analysis, we have identified that it's a systemic issue where there was system involved. Because what happened is that they've punched the payments into the system. As a result, the lawyer go to get an order of which now they are forced to attach the bank account, and the system will pay the money automatically because it's been loaded into the system. So it's a system issue, but of course there are people who are involved who are supposed to have looked into it, that whatever is being paid according to the system, there's not been any rates that has been executed against the RAF. But in terms of the payment, you could see that that happened. But it's a systemic issue that we've recommended to RAF that they need to reconcile before they make any payments. So that's what happened. But we didn't see any fraud from any individual that done that. Then the issue of the ransomware, we have not find any impact in terms of the information that we have needed. So we're just highlighting it, but as and we request information, we are able to align to see whether is the information part of the information that was lost because of those ransomware. But so far, there isn't any impact in terms of the information that we have requested, meaning that that has not yet affected the part of our investigation. Then on the issue of the sheriff, we have not found any evidence to implicate the sheriff in the process of the duplicate payment, because the money that was obtained by the sheriff was paid to the attorney. So in terms of our investigation, all the money was paid to the attorney. The sheriff didn't keep any money. So far we have not seen any infraction against the sheriff. Then the other matter, how many lawyers are we likely to refer? So far, we have identified 5, but the investigation is still ongoing, of which some of them will be added as our analysis is still ongoing. But so far, additionally to what we have already referred, we have identified 5 that we are looking at, and the investigation is still ongoing. And on the issue of the interest, we make sure that as the lawyer, the attorney, they sign the AOD, we include the interest from the date that they sign the AOD so that they can pay money back with the AOD. So we do take the issue of the interest into heart when we ask them to sign the AOD. I think if I remember, these are all the aspects that I needed to answer on. Thank you, Chair.
Thank you, Honorable Chair. That's the first set of questions that were posed.
All right. Thank you very much. May I ask Honorable Matiwane?
Chair, before that.
Yeah,
please.
Is it a follow-up to your previous questions?
It was because I think Advocate Mutivi misquoted me, and I just want to clarify that on record.
Let's correct that.
Yeah, to say it's not like I'm saying to you, you don't have a right to come to the core committee. I think I must put it that very, very clear. The only thing which I wanted to find out was that the preliminary report is, do you have a preliminary report? Because as I said earlier, for me, because you've got a proclamation, like normally do, this is not the only matter which you've dealt with us as a committee. I was asking about, in particular on this matter, that already do you have a preliminary report? Or because as I'm saying, that has to be sent to the president anyway, and your final, will be dealt with at a later stage. But for now, what I wanted to find out was that, do you have a preliminary report? Because we don't want to deal with matters of like gossiping in a way. I'll put it in that fashion. And my last question, which was there, which was not answered, was the issue of do they disclose to the ref that they are lawyers? I mean, they are investigators to ref. That was not answered. Thank you, Chair.
All right, thank you very much. We'll take those together with the other questions, Advocate Motibi. So, but start Honorable Skosan, and then it's going to be Honorable Matiwane, and then Honorable Isaac. I don't see any other hands for now. So let's, Honorable Madlala. So that's 4. So it's Honorable Matiwane, Honorable Isaac, and Honorable Madlala in that order.
Bhoti sekwesihlalo nakumalungu e-committee. Also extend my greetings to the Road Accident Fund. You will forgive me if I repeat some of the things that might have been said. I had gone out, as I indicated on the WhatsApp group, that I would be excused at 11:15. So I had gone out for those 15 minutes. So I'll start off by welcoming the presentation by the SIU. It paints a picture of a systematic breakdown of controls within the road accident fund. That is the perception that you are getting from reading the reports. When you look at the cancellation of the panel of attorneys, a cancellation without a backup plan points to a lack of planning and to take into effect the financial consequences that will flow from such actions. So this is a welcomed intervention in the sense that the use of the state attorney is a measure to cut costs and to build state capacity. However, the manner in which it was done leaves much to be desired. I'm interested to find out what were the reasons for, if the SIU was able to get to that, what were the reasons for incorporating the one service provider in the corporate panel of attorneys from the GEPF? Is this one service provider the same service provider that was allocated 90% of the work? Because for us, it appears as though that there is a lapse in oversight by the board, where it seems as if it approves some decisions without conducting due diligence. At the same time, you get the perception that the executive seems to be taking advantage of this perceived weakness of the board, or it is deliberate in its actions of not following or adhering to SCM regulations. So it is quite concerning to hear that bribes might have been paid in relation to the allocation of work, as demonstrated by the 90% allocation to a single law firm. On the CN's project, by all indications, this contract was undertaken with a service provider in mind. That is what we are getting. Hence, the manipulation of criteria to favor a particular supplier. It must further be noted that it is the core function of the Road Accident Fund to do payout claims to beneficiaries. Therefore, the appointment of the two service providers was not adequate to address the backlog, as demonstrated by the dismal performance of closing only 96 cases out of 2,472. If you look at the remainder of the contracts, that is the office buildings and the rental of motor vehicles, it appears that the same modus operandi of disregarding SCM policies and regulations with a view of awarding work to a preferred service provider or service providers is in place. One can only assume that such actions are motivated by a financial benefit that may accrue to executives of the Road Accident Fund should their preferred service provider get awarded the contract. From the listed cases under review, one gets an indication that there is a scheme that is run by Road Accident Fund employees that disregards SCM regulations, which points to a possibility of a racket being run between service providers and employees. This can be true for the duplicate payments, as they point to a lapse in controls which is being exploited by attorneys. A simple recon, as recommended by the SIU, would curb this practice. However, the reluctance by management to act on this leaves much to be desired. Thank you, Chairperson, for affording me an opportunity to make my inputs.
Thank you very much, Honorable Matiwan. Honorable Isaac.
Chairperson, good morning. Thank you for the opportunity. Good morning to Advocate Motibi and Team SIU. Thank you again for the excellent presentations and the efforts. Chair, look, I'm not going to get into the detail. I think the colleagues have expressed and gone into the detailed report regarding the various matters and issues at hand. All I want to say is, and I think I speak for the committee, Chair, these matters are ongoing now for a protracted period of time. It is my opinion, of course, that the Road Accident Fund is being plundered. And of course, it's become a cash cow for many individuals. And I think we can see that it's pretty blatantly clear. And there remains absolutely no accountability. Now, Chair and colleagues, considering the discussions we've had with the AGSA on the 11th of March, if I recall correctly, and then again our discussions with the Road Accident Fund themselves on the 18th of March, and of course now today our discussions with the SIU, the question that arises for me and that stands out is, what do we do about implementing some sort of a crisis management of this institution? I mean, Chairperson, seriously, I think, we need to, first and foremost, need to begin in declaring the CEO and the board as totally unfit for purpose. That is my opinion as a member of the committee. I mean, the injustices that are being committed at the RAF, let's be honest, are failing South Africans totally. And South Africans are looking to us and the institution of the SIU and the AGSA in terms of what concrete issues are we going to now put in place to address these matters on an urgent basis, purely because the investigations, yes, indeed, have to go through their processes. I understand and comprehend that. But, like we heard at yesterday's meeting, again, how people, duck and dive and court cases after court cases, and next thing, another 3-4 years have passed. And this plundering continues unabatedly. So, Chair, mine's more in terms of a closing remark. What are we now going to do concrete in beginning to declare this CEO and this board at RAF totally unfit for purpose, so that we can begin to move forward, and whatever processes must happen in terms of the SIU and the investigations and the charging and disciplinary actions, those must happen. But I'd like us to bring something concrete to the table. That, Chairperson, is my input, and I am very grateful for the opportunity. Thank you, sir.
Thank you very much, Honorable Isaac. So I see 2 more hands. Let me just complete it because I'm also, I'm sure we can finish before the parliamentary lunch time. So I'll give a chance to Honorable Kubeka and then Honorable Atkinson.
Thank you, Chair.
Actually, I am being delinquent, Honorable
Madlala.
Madlala. I'm being very delinquent. I'm going to give you a chance, and then I will get answers. And then myself and Honorable Kupek and Honorable Atkinson will be in the last round. My apologies.
No problem, Chair. As a recent youth click, I was going to take a chance anyway, even if you had not given me now. Because you gave me earlier. Thank you, Chair. I think one obviously would be to, as usual, appreciate the work by the Special Investigations Unit. And I think it is important to note that this would appear, or this is a preliminary report. It's a work in progress kind of a report, with individuals given their right to reply to what may appear as possible transgressions that link to their names, including disciplinary hearing referrals. And noting that would obviously land us in a position where we are unable, or I am unable, to make conclusive remarks, because following their replies, one may come to a totally different conclusion. I'm saying the report may lead to a different conclusion. Maybe that there is no need for a disciplinary hearing, or that there were no benefits to executives or whatever. So maybe we'll wait for the final report to make some comments around some of these issues, particularly where there's still a reply is expected. Maybe to comment will be to comment on the issue of the duplicate payments. Maybe let me start there because I understand that some recoveries have been made. So in as much as the report is ongoing, but there are firms that are approached and which then make commitments for recoveries. So it will be just to confirm if then there is a process to deal with those law firms, including where there's not been a commitment, but where there's been conclusive evidence that a duplicate payment was made. Because I think a duplicate payment is it's a straightforward issue like that, easy to detect. It's that you just received two payments and it's been this long and you have not reported that you received that extra payment. We don't know if there was kickbacks involved, but as a company, you ought to have a level of responsibility to bring back that money without having to be pursued by the SIU. So in terms of the blacklisting of these companies with treasury and all of that and reporting to the body, the law firm body. I know that we still owe it to ourselves to have an engagement with that law society. So maybe it would just be to check if there's any follow-ups that are happening in relation to these companies, because we're speaking about a lot of money, up to the value of 340 million. The issue of ref executives, I think we'll just need to get a report on the vetting status. I know that it has been said in this meeting that none of them have been vetted, but also I agree with the chair that this matter has been raised before. If they were not vetted then, why have between then and now still why do they remain not vetted? But I think that we'll have to engage with RAF and maybe just give RAF a timeline to say within this particular period to expect that they should have done this exercise. Because the fact that you did not do it beforehand is a problem on its own. But also, if you still don't continue not doing it, you are then exacerbating the issue. You are now responsible for it, even if those people were recruited before you came in. But upon arrival, this needs to be a finalized and concluded exercise. And I think they did give us some report in our previous encounter with them, even though they were awaiting some outcomes, but they had done some process. So I think maybe we need a detailed report and just put in some timeline so that this matter can be put to rest. The issue relating to there was one issue where I need clarity. It said that there was okay. Also, but besides vetting, there were appointments which were done without due processes followed. I just need to follow up on that matter. Because if there's evidence, unless if we're also waiting for a right to reply on it, but if there's evidence that the people that are appointed without due processes followed, what has been the consequence management around that? Have we then advised that there should be immediate suspensions pending further investigations? Because also in relation to the other issues, even though there's a right to reply, but the modus or the normal way of operations is that if there are serious allegations involving putting allegations that may put the name of the organization to disrepute and all of that there would normally be immediate suspensions pending the finalization of investigations if we believe that there's a prima facie cause for a case, because we're dealing with issues that matters that are very sensitive and at a high level. It includes a lot of monies where repeated offenses could be continuing whilst we're finalizing the investigation. So I just need to know the in-between process to say what are we putting in place currently to alleviate or minimize the possibility of exacerbation of a potential problem that we see. Because a suspension pending investigation is not a punitive act. It is rather a preventative strategy to say, let us recuse you from the process so that we allow the investigations to go on. If we finalize them and we feel that there's no issue, then fine, you come back to work. If there's issues to respond to, then you are subjected to a disciplinary process. But we can't let it be whilst we're dealing with that. So then the last issue, I mean, that was on the process of the executives, where it said that some of them were appointed without due processes being followed. Then on the last one, there's an executive absconded what's facing 12 counts of allegations with the city of Johannesburg. I don't know if I read that statement, wrongly, or I misunderstood it. So the abscondment is happening at RAF, and the allegations are with the city of Johannesburg. I just need clarity on that. So maybe we may have mixed two issues. This is an official who was appointed whilst having counts of allegations with the city of Johannesburg, and has just absconded at RAF, or there are allegations relating to RAF as well. I just need some clarity on that. The sentence just doesn't, give me some coherent understanding of what is happening there. And I think I'll just pause there. Thank you, Chair.
Thanks very much, Honorable Madlala, and my apologies again. It was not on account of you being a recent youth leaguer at all. Let me hand over to the colleagues from the SIU.
Well, thank you. Thank you, Honorable Chair. On the Honorable Skosana, the follow-up questions, and really thanks for clarifying the views around our appearance at Parliament, in particular SCOPA. I think we are on one page on that. The issue around the reports, I've just done a double check with the colleagues here. We've up to date presented 2 progress reports to the president. So I think that that should really indicate where we are in terms of progress or stroke preliminary reports. The progress reports submission to the president is also provided for in the legislation. So in the ordinary run of process, we do advise, because the president would be sort of the custodian of the reports. The reports can be obtained by request from the president's office. Do we disclose to the REF that we are lawyers? When we start the investigation with any state institution, in particular at REF now, I said we present a letter of engagement. Amongst others, we also disclose the investigators that will be investigating, whether they are forensic lawyers or forensic investigators and so on. So I've asked my colleague, Mr. Lekgeto, just to confirm that. So yes, we do disclose who will be investigating at REF. Yes, Honorable Matiwani, the firm that was incorporated, whether it's the firm that received the 90% work. So Mr. Lekgeto, if you can please respond to that, or any of the lead investigators. As we indicated, we will also look at the responsibility of the board when it comes to oversight and what was required of the board, and will make appropriate findings. With regard to Honorable Isaac, we do agree that the matters by their very nature has really taken a while to investigate. So I've said to the team as we were preparing for this presentation that we really need to speed up. Of course, we will respect the process of the right of reply. We can't just speed it up and then end up prejudicing the people who are making the rights of reply. But we will take that into account. We need to ensure that this investigation is brought to a close. Honorable Madlala, the observation is really very accurate. The presentation we are making in many respects is work in progress, and that's why. But almost at the end, when we get to at the stage of giving right of reply, then it's really an indication that we are drawing to a close. So once that process is done, we will then be able to finalize. But indeed, in between, there are those instances where we reach finality with regard to a certain aspect, and that's why we are able to refer evidence pointing to criminal actions to NPA. We are able to refer, in some instances, matters relating to disciplinary action. We're able to refer to LPC and so on. But in the main, as we have indicated in the presentation, the right of reply process will be ongoing. Duplicate payments, any follow-ups with the lawyers? Yes, indeed. We do follow up with the lawyers, and that's why in the presentation we have said we have identified those that are not honoring the acknowledgement of debt, and we are now going to go for them legally, either to either institute civil proceedings to get them to pay, and then of course any other related referral. With regard to the allegations, and in fact, I did during the break, Honorable Chair and Honorable Madlala, I indicated to the team that in the presentation we are just referring to the allegations received. We should have gone further to say the allegations will receive assessment. We are taking them through the governance process of SIU. If they fall within the mandate, which ordinarily they will, looking at them, we will check if they fall within these proclamations that we have. If not, we will seek an amendment of the proclamation. Now, issues relating to employees that are pointed to, it will probably be as we process the proclamation, we can indicate to REF that we are, and then they can really take a decision on whether to suspend or not to suspend the individuals. Honorable, Mr. Lekgetho, in terms of the allegations themselves now, with this person that absconded, I think the wording, as I understand, Honorable Chair and Honorable Madlala, is that the allegation says REF appointed this person from who absconded from city of Joburg. So it looks like he had issues that he was facing at city of Joburg, and he was appointed now at REF. So Mr. Lekgetho, you can really confirm that, and those are part of the allegations that we have received recently, which we are assessing to investigate. Mr. Lekgetho, please, for those aspects that I indicated.
No, thanks, Advocate. On this last one, yes, the person was appointed at RAF, but he absconded at the city of Johannesburg. I think the chair did explain on it that there's a recent communication that they received from the city of Johannesburg to indicate that the person left before the charges could be preferred. So it means they were, yeah, but that's the thing. He left city of Johannesburg and appointed the RAF, leaving charges at the city of Johannesburg. But this is one of the allegations that we received that we have not dealt with it because it is out of our scope. And it's one of those matters that we are currently assessing to see how we can incorporate it in our investigation, either through the extension of the proclamation or to get a new proclamation. Thank you. And on the other aspect regarding the other matter, I'll ask Mr. Maseko to respond.
Thank you so much, Honorable Chairperson. The issue that has been raised is around the corporate panel of attorneys, particularly on the one attorney that has a law firm that has been incorporated. We have engaged extensively with the GEPF in that regard, and we are yet to confront the RAF with the information so that we get the version to that extent. So that's where we are with the matter.
All right. No, thank you. Thank you, Honorable Chair. Those are our responses to the set of questions.
No, thank you. So let me just deal with this. So, Honorable Madlala, we dealt with the issue of the former City of Johannesburg employee extensively. in the last meeting we had with the Road Accident Fund. It was actually the reason I implored the chief executive to make sure that his direct reports are vetted, so that he does not need to answer these kind of allegations. You may recall that conversation where I said you shouldn't be having to answer these kind of questions if the vetting was being done. But the person was facing allegations of financial malpractice. I'll just frame it that way. Otherwise, in the committee record, I was very specific about what the allegation was pertaining to Regiment's capital. And so this person was it's a chief investment officer. It was Mr. Sfoot. This is on public record. And he had not been, so I asked the chief executive if this person, if he knew about the allegations. And he said that not specifically, because the person had resigned from the city of Johannesburg. I then asked the committee secretariat to simply clear up the matter for us, because it wasn't clear in the meeting whether the charges had been dropped and the person subsequently left, or the city of Johannesburg dropped the charges after he left. So we wrote to the city of Johannesburg, gave the employee number because it's also in court papers, and they came back to us yesterday, the executive mayor, to say that they actually would have carried on with the charges were it not for the fact that the person resigned. But there's a detailed response to the questions from the committee, and I'll just ask the committee secretary to furnish that to the members, as well as to you, because it's a submission that's been made to this committee. It's to clear up a simple fact. That was simply to assist us, therefore, in follow-up communication to the Road Accident Fund about the vetting, because that was the core issue at hand. We had no idea about any other allegations and that kind of thing. We're discussing the vetting at that time. Anyway, so Honorable Mandlana, I hope that clarifies what the matter in hand is. Mr. Dekgetho, that would be the allegation that you've received, because that's the only case I know about where there is a senior employee who was facing charges in the city of Johannesburg, who was employed by the Road Accident Fund.
That is correct, Chair.
Okay. I think we've dealt with that. I mean, how the SIU deals with it is up to the SIU. We will make up our own follow-up inquiries, because for us, the core issue is the vetting and the impact of the vetting on the organization, which is an issue I know all members are very concerned about. Can I then give an opportunity to Honorable Kubeka and Honorable Atkinson? I think that will be our last. I've got a few clarifying questions, but I'll ask those last. They're not that critical. Honorable members, Honorable Kubeka, please go first.
Thank you, Chair, and greetings to honorable members. Greetings to the SIU team led by the ever capable advocate Motibi. Chair, I think first and foremost, we've always been happy with SIU and the reports that they give to us as a parliamentary committee. With that being said, Chair, today I must question this practice of presenting preliminary reports as conclusive reports, because I don't believe that we have ever received SIU here, and you'll correct me if I'm wrong, Chair, where they have given us a report that says it appears or it is alleged in so many instances. Because, for instance, it says in one of the slides, it appears that an estimated total of 141 million rand was an irregular payment, since there was no approval from the board. Now, I would here, Chair, like to echo Honorable Skosana's sentiments when he says we can't be speaking about allegations at this level, and we can't be speaking about allegations in this committee. Again, Chair, it is alleged that RAF cancelled the panel of attorneys without a backup plan. Is that the case? Because now, how do we pronounce on anything when it is an allegation? It is alleged. I do believe we need a more concrete stance on those issues. Again, it is alleged that the contract was awarded irregularly and unlawfully. You see, Chair, I note this because today we know that in the Zondo Commission, and this is from now the NPA, that 0.01% of the cases that they're investigating as the NPA that emanate from the Zondo Commission, they cannot look at anything further because bulk of the information that was provided to the Zondo Commission, which was used to lambast people and drag people's names through the mud, was unfounded allegations. But those people's lives are ruined, Chair. They are ruined for good because of the Zondo Commission. So, Chair, I warn against this in this commission, in this committee as well, that we cannot, Chair, have allegations that we're going to bring to this level. Because as this committee, Chair, we must appreciate thoroughly that these committee sittings are public knowledge, and that we must also appreciate that they are aired to South Africans. And we must also appreciate that the media will run with whatever this committee says, and that those media reports will not say that whatever is being said in this committee was not a conclusive report. It will not say that these are allegations. The media will report it as the gospel truth, and they will run with it. And once they run with it, and we take it up and we lap it up as a committee, when some of these things and some of these people who are mentioned in these reports have not had the right of reply. I think, Chair, moving on from that one, for me, Chair, where I sit, there's no need for a rationale on monies that came from RAF into any executive's account. If money came from RAF and it came into executives' accounts, if that's the case, and this is a final report on that matter, those people need to be dealt with decisively. If the SIU has confirmed that the money came from RAF into the executive's account, that should be game over for those executives. And I think, Chair, just lastly, I'm not sure who can, if Advocate Matibi can assist us here. I know of a Mabunda and others versus RAF case where the issue of the defense panel of attorneys was taken on review. Can SIU or Advocate Motibi give us an indication as to what the SCA found was the correct or was the lasting or binding finding that they found as the SCA? Thank you, Chair.
Thank you, Honorable Kubega. Honorable Atkinson.
Thanks, Chair. Chair, this is a follow-on of your comment about the vetting. And I'm going to ask Advocate Matibi here to give me an indication, because it's actually a matter of law, really. The fact that people have not been vetted means that they actually haven't been lawfully appointed. So would it be correct to say that any decision that they've made, or any proclamation or anything like that, actually has no standing in law? Because my concern here is that the lack of vetting actually means that anything that is done by anyone that has not been vetted in the Road Accident Fund means that anything that they've said can actually be challenged in law, because they're not actually lawfully appointed. And it's as serious as that, actually. And then the second point I wanted to ask was, if directors are found to have acted in a delinquent fashion, and I'm talking here about the issue around the panel of attorneys and a number of other factors, could actions be taken to have those people be declared as delinquent directors so that they cannot stand as directors again for companies in the future? Because I think, when we come to the accountability issue, we need to make sure that the same people don't keep on popping up on our scenario to carry on with their corrupt actions elsewhere. Thanks very much.
Thank you very much. Let me give a chance to the SIU, and then I'll also deal with the same issue, Honorable Kubeka, about how we deal with reports. So, Advocate Motibi, the comments directed at me, leave them to me. Deal with the other equally substantive matters the members have asked you, including the questions of clarification, of course. That's on similar matters.
Thank you, Honorable Chair. Honorable Kubega, I think I've responded to this, the preliminary versus final, and it means exactly what it says. It's preliminary, so it cannot be preliminary and be conclusive at the same time. So at the moment, where there are areas where we have concluded the investigation, for example, where we have concluded that attorney XYZ have gotten the money or claimed irregularly, and then we have made a definitive finding, we have indicated to the committee, and that we have signed AODs with them, right? But in instances where there still needs to be, rights of reply. Unfortunately, it's a legal process. We may have factually found monies that have been deposited into executives, but we are enjoined legally to give the executive a right of reply before we finalize the investigation. It may look as if we can finalize it and say, hey, you know what, this is the money paid into your account. We deal with you, but we may be found wanting from a legal process perspective. We can't be speaking about allegations. If you, Honorable Kubega, if you look at our slides, at the top, we sort of try to summarize what were the allegations received. And as we go down, we then indicate what are our findings. We're not coming here with allegations alone. We are saying these were the allegations, and these are the outcomes so far. This is what we've found. And if there are any outcomes, whether referrals for discipline, civil, or NPA, right? So we are not just focusing on allegations. We are trying to give a sort of a comprehensive picture, albeit summarized. How do I, well, the others really, I think, are comments that I cannot sort of authoritatively respond to, comments relating to media and all of that. With regard to the case, Mabunda versus Ref, I'll ask my colleagues, Mr. Lekgetho, and even the legal persons in the team, if they are aware of it, they can probably comment. If not, we can go and look at it and see what it says. And then, of course, if need be, we can comment to the committee in writing. But and really thanks for referring that to us. We'll look into what it has said. But our legal team do make sure that they really look into all the areas pertaining to any investigation we do. Honorable Atkinson, let's see what did this SCA find? Oh, this was around Mabunda. Okay, we'll look at that case. Honorable Atkinson, the vetting process, I mean, we are aware that in many instances, there are appointments that are made, but the appointments are made subject to. And that is a very operative word or words subject to vetting, right? Now, you will know that an individual X can be appointed into a position. The appointment on itself at that time will stand, right? But at the time when the vetting process is done and the person doesn't pass the vetting and so on, as I sit here, I mean, we can probably still do some legal inquiry, but as I sit here, the decisions that the person would have made after a substantive appointment, those decisions will still stand. I do not think that there will be a legal basis to sort of strike them off or set them aside. Now, it could be that at the time where the vetting is completed and this person does not meet the requirements of vetting, and then at that time, the person will then, of course, either be dismissed or follow the process of dismissal for not having met one of the requirements being the vetting. As I say, I'm giving a sort of a high level view. It's my view at this stage. We can still subject it to further legal analysis, which we'll do. Declaration of delinquency. Oh, yes, indeed. It is our stated view at all times where we investigate state entities that if we find that the board of directors has not executed their fiduciary duties as expected, it of course depends. I mean, there's court decisions around this, the extent to which we take into account whether, over and above having held them to account, do we go further and declare them delinquent? There's really materiality and severity issues that we look at. We have done this in some of the investigations where we have gone and really ensured that the delinquency process is followed. So it will be no different here. If we find that there's areas where the board should have acted and they didn't, and what is the severity thereof, we will return our findings. Thank you, Chair.
Thank you very much. So Honorable Kubek, and I think the rest of the members, a lot of the reports that we get from the SIU are actually interim because of the length of time it takes to conclude the investigations, conclude the whole proclamation and submit a report to the president. And one of the reasons I said I want to ask Advocate Mutibi some clarifying questions was actually to confirm things such as this. Even in instances where people are there's disciplinaries recommended, it often happens, and please, Advocate Mutibi, you can step in and correct me. It often happens that there's a referral to the NPA or the Hawks, or well, in this case, it's the NPA and then to the Hawks, disciplinaries, civil recoveries, and so on, before a final report has been submitted to the president. Isn't that so, Advocate Mutibi?
Honorable Chair and honorable members.
So in other words, do you wait until the whole investigation is concluded and then you take action, or at the point in which you've got sufficient evidence for action to be taken, you take the action anyway, even if a final report has not been presented to the president?
The latter is accurate, Chair. We do not wait until we submit the final report to the president.
Yes.
Any point in time where we are investigating a particular aspect, if we finalize the investigation on that aspect and we find that there's action that requires to be taken, we do either refer to NPA or refer for discipline or institute civil litigation to cancel. Most of the cases, a contract are cancelled in between or disciplinary actions being taken before the final report is submitted. In the final report, we appraise the president of what has happened up until the final report. So, Honorable Chair, of course, that is in the interest of making sure that actions are taken and taken speedily. If we were to wait until the final report, the issues around consequence management would be found wanting. Thank you.
Okay, no, thank you. So, but I think maybe the concern from Honorable Kubeka still stands. So the steps that I take in this instance, Honorable Kubeka, is, and I may have inadvertently created the problem. One of the things I take particular care as far as possible is that no names are mentioned, even the names of the institutions involved in that sort of thing are not mentioned, because I think it's important that they mentioned at the point where everyone concerned is comfortable that the name can be mentioned firstly. That's the first thing. The second thing, I guess substantively, the question is whether Parliament should be updated only after people have received a right of reply. My view, and is reflected in this presentation, and we canvassed this earlier in an earlier sitting last year with the SIU, that where this must still happen, the SIU needs to disclose that information may arise which might change the eventual conclusion. And my clarifying questions to Advocate Motibi pertain substantively actually to the procedures that are then going to take place, and also just questions around treatment of information and allegations, because the public is also watching. So it's important that so if you can just allow me, because I think as chairperson, I have a responsibility to play that role. So the questions I'm going to ask Advocate Motibi are not necessarily pertaining to the to very specific allegations and who's wrong and who's right, but I need us to provide a context for people to understand where we are in the investigation. The first one I wanted to ask Advocate Motibi is about the engagement with an entity. And I'm going to play something back to you based on the reports that you've given to us, that it may occur, or it often occurs, that some of the senior people in the organization, including the accounting officer and members of the accounting authority, i.e. the board, are implicated in the investigation itself. How do the arrangements normally work? So you're saying, for instance, in this case, you're going to go and speak to and update the board. Now, there are people who may be board members, and I don't know which executives are, but they're usually executive directors. How do you deal with that? Because the same people might then, understanding where the investigation is into themselves, then go and take further action to conceal or whatever. And I'm asking this as a general practice, not just to the road accident fund. So how do these updates normally work?
No, thank you, Honorable Chair. We really have had to deal with those kind of considerations very, very intensely. The engagement with the entity, of course, at the time of the engagement, that's when we really kicking off the investigation formally. At that time, we obviously wouldn't know who will be implicated, who would not be implicated. It may be, and as you said, Chair, this is really just the general view. It may be that in some instances, the allegations were saying the accounting officer X, did X, Y, Z, and so on. But at that time, at that stage, they really remain allegations, right? So as I said, the letter of engagement really enables us to engage or start the process of investigating, and that the state institution is aware of how we're going to go about, what will be the costs, and so on. So at that time, there wouldn't be any sort of indication. We still treat them as allegations. However, as we go along, evidence may be gathered that points to say the accounting officer or accounting authority. Chair, in that case, we really take due care. We take due care that that we would not be in a position to present either to the accounting officer or accounting authority. We would possibly present to the executive authority. Because, Chair, we really do a balancing act here, that the accounting officer needs to know, or the state institution needs to know where we are. In many instances, we also submit progress reports so that we are paid. Right? So we really do a balancing act so that our investigations should not be prejudiced. That same balancing act, Honorable Chair, we take due care when we prepare presentations to parliamentary committees, right? So that investigations are not prejudiced, right? Or any other entity or any other individual is not unduly prejudiced. The point you have made, we've been talking about, we've referred persons of interest, this and that, and so on. In that case, we really safeguard that we shouldn't mention the names of individuals that are called persons of interest prematurely before the process is concluded. In that way, we believe we're not prejudicing anyone. The information that we share in the presentations, we believe that is the information from an update perspective that the committee need to be appraised of, and in no way are we of the view that it would prejudice the investigation or anyone. As we now go towards the outcomes and actions, right? This evidence we will compute and put in a final report, and of course, when we go to the special tribunal and so on, those take their own processes, and the evidence gets tested in those processes. So, Honorable Chair, really you've hit the nail on the head in terms of the kind of a balancing act, our accountability to report to Parliament, and of course I'll still call it accountability as well, to sort of update the state institution so that when they pay, they would know what they are paying for. But as I commented before, that there is no legal provision that says we need to report to the state institution in any way. It's really from a point of view, well, for lack of a better word, really to say we are really appraising them of where we are, but we are guarded. We are really guarded. We take due care that the investigation should not be prejudiced. Thank you.
So in this case, have you had the opportunity to update the ministry at all on any of these investigations?
Thank you for that question, Honorable Chair. We have had the opportunity to present to the minister and to the deputy minister. I can't recall the date, some time back. So we will reach out to the minister in the same vein that we would like to keep them appraised. We'll reach out so that the executive authority is also appraised of the status of our investigation.
All right, thank you. No, it's just a few questions left. So let me just understand the point at which you give people a right of reply. So at this stage, you've gathered all the information that you thought that you need, right? However, the implicated persons may give you evidence which puts that same information in a different light. And therefore, where you thought there is something untoward, it may turn out to be quite fine, actually. And I think yesterday or the day before when you were presenting, there were instances where no further action was taken because the allegation was proven to be untrue. But I just want to understand, and I will make an example from the presentation that as far as you know, as you can see, there were monies that flowed from a law firm to some senior employees of the organization that you know, because you know that the account belongs to that person. What you are asking them is what was the payment for? Because the explanation of why the payment is there may be quite fine, actually. So what you're telling us at this point is you know that there were payments that flowed, but the person must explain the payments as to what they were for. Would that characterization be correct, or that understanding be correct?
Chair, that will be correct. That is so correct. And really, in brief, and I've just checked with my colleague, Advocate Vanara, who can say it with even more authority, because there has been court cases, instances where the courts have said to us as SIU that in this case, the court's view is that we didn't give sufficient, right of reply and so on and so forth. So I've indicated to him that he can come in. So the point at which we give right of reply, Honorable Chair, is really at the point where the investigators, like Mr. Lacheto and the others, have reached a stage where they're saying we have evidence implicating Mr. or Ms. X, and then they seek to make final decision or a finding. In many instances, Honorable Chair, because those kind of findings come to my desk before they are finalized, and I would scrutinize to ensure that the legal process has been followed. And where I find that we are falling short of the, for example, right of reply, I would send it back and said, no, we will come second if these people take us to court. Go and ensure that the right of reply is afforded. Advocate Vanara, if you can please just come in from a point of view of what we have experienced, understanding the chair's question, at what point, even with the monies that have been paid, Honorable Chair, as I said, your observation is accurate. We've had instances where, we see large sums of money in people's accounts, and then we are able to track, and our accountants, as I said, they've got the skills to analyze. We're able to see where they came from. But in some instances, we've reached a stage where a person really is able to explain, right? And Advocate Vanara has dealt with some of the instances recently in some of the investigations. So, Advocate Vanara, do you want to come in, please?
Good afternoon to the Honorable Chair, Honorable members, and thanks, Advocate Motibi, for the opportunity. Chair, the right of reply is based on the principles of fairness, firstly, but also to assist us with practical challenges that we come across. You have correctly articulated the position insofar as the examples that pertains to the current situation, and that does not require any repeating. It is important, and case law tells us that before we submit a report to the president, final report or a provisional report that has got adverse findings against any individual, natural or legal, we need to afford that specific individual an opportunity, a right of reply. We do go to court, Chair, or the special tribunal before we submit a final report to the President, as all we require for litigation is evidence, not a presidential permission to institute civil proceedings. In those instances, the law does not require of us to give an implicated individual a right of reply. However, we do still, for practical considerations, give that individual or individuals a right of reply because it only makes sense for us before we incur cost and institute proceedings that we are aware what were the circumstances or what is the position the other party has in respect of what would have transpired. That response may even lead to us not even pursuing the intended civil litigation, which is beneficial to us because our processes are not geared at victimizing people, are geared at pursuing genuine civil litigation outcomes. The second practical issue is if we do not afford an individual a right of reply, we are not tying that person to a version that we could assess, agree or disagree on when we go to civil litigation processes. Now, when we get to the court and we have tied ourselves to a version without tying the other party to a version, it's easy for someone to go to a lawyer and ex post facto find a plausible explanation that could be explained to a judge, and we lose that case. So those are some of the practical considerations. I thought that I would add to what Advocate Mutibi has indicated. Thank you, Chair.
No, thank you very much. Can I ask, I really do, please bear with me because there are some issues. So during the course of the investigation, and there's a question that Honorable Skosana had asked, during the course of the investigation, especially on the issue pertaining to the delegation of authority of whoever is chief executive of the Road Accident Fund, vis-a-vis amounts of 10 million or above, who would you speak to in this instance? Do you speak to the board secretary to get access to such records as may be necessary? How do you ascertain where a board is expected to have taken and recorded a particular decision and then it didn't? How do you obtain that information? Or how do you reach a conclusion, at least that a preliminary conclusion that, well, you know, this didn't take place? Yeah, can you give the committee an insight into that process?
Right. Thank you, Honorable Chair. You know, as we were preparing for this presentation, it was a specific check with the team that we obtained the delegation of authority framework or document from the institution. The answer is yes. And now we use that delegation of the authority to test the process which was decided upon. If any process has got value and the value is more than 10 million, we've taken into account what Advocate Skosana, Mr. Skosana has said, Honorable Skosana. The team will really have to verify that. I'm not aware that we have a delegation of authority that indicates that the delegated authority was extended or increased to 40 million. We have noted that. But to your question, Chair, if we find that a certain process or procurement process, say it's got a value of, let's say the delegation of authority says CEO 10 million, and now he signed on 15 million, for example. And we want to know if the board ever looked at that, or any subcommittee of the board. We will, of course, have to inquire from the board themselves. If there's a chair of the board, we'll probably speak to. If the board had delegated to a subcommittee, we'll speak to that subcommittee. So there's really various interactions in this process which the investigators has to follow to ensure that we verify whether the delegated authority was executed at the delegated level. Mr. Lekgetho, you're welcome to add if I may have missed anything.
Yes, please, as regards to therefore this instance, because there are matters that pertain to the board, right? Because we also need to decide what to do vis-a-vis holding the minister accountable. So I'm asking this so that we can then ask the minister specific questions and not think that certain things took place and then they didn't take place and so on. So with that explanation, template explanation you've given, which I appreciate, so I'm assuming, am I correct to assume that conversation took place here? And the conclusion at this point is we've seen the delegation of authority. We know which structures are supposed to process instances where this authority, basically this delegation, is to be applied, and there is no record of the decision having been taken. Instead, some of the permissions were given a year later when the expenditure, which in terms of the Auditor General would fall under unauthorized expenditure, I suppose, because the authority that should have given it wouldn't do that. So I just want to understand that this process that you describe took place in this instance.
It happened. Mr. Lekgetho, or any Mr. Masego or Mr. Lebopa?
Mr. Lekgetho,
given that framework, what has the investigations done up to now with engagements with the board and to determine whether the delegated authority was executed properly?
What I wanted to add, Honorable Chair and Honorable Member, is that the delegation might have been reviewed now, but when we investigate, we look at the particular point. At that point, what was the applicable delegation of authority? For now, as we speak, it might have been reviewed at a higher level, but during the transaction, what was the delegation of authority? Thank you.
Yes, you have not responded to the question of the chair. Yes, and thank you for that. I'm sure the honorable committee would find it useful. But what the chair is saying, as those checks of the investigators,
have they taken place in this case? Yeah.
And perhaps Mr. Masego can come in.
No, thank you very much, Honorable Chairperson. Yes, we have done the checks. We have looked at the delegation of authority that was applicable at the time, and the information, as it were, it would be received from the nodal point that is nominated in terms of the LOE. So as we request the information in terms of the Section 5 2A, we would be very specific of the documentation that we are looking into, as well as the dates in which they were applicable. And such information has been received from the Road Accident Fund through the nodal point.
No, thank you, Mr. Maseko. So, Honorable Chair and Honorable Members, really without going into details, the investigators, amongst others, and this is what I would implore them to do, but if there's any decision by the board, those decisions are minuted, there's resolutions, there's a whole lot of process and documentation that they can ask for to ascertain whether the board has decided if it had delegated, whether the delegated person decided appropriately. So as he says, they would have requested certain documentation to verify whether the delegated authority was executed appropriately. Thank you.
All right. Thank you. So I'm really getting towards the end, and I have noted you, Honorable Kubeka, and I'll give you an opportunity just now. So look, I'm glad then that the process is clear. I just want to ask two questions, and then I'll be done, unless something else comes up. So typically, this nodal person is basically, if I understand you, it's a person delegated to assist the SIU in obtaining information, getting access to witnesses, etc., etc. Would that's this person's job? If that is so, at which level are they in this case?
Mr.
Is it a senior person? Is it a junior person? I'm asking because the speed with which information gets made available by institutions has a lot to do with who's asking.
Yeah. I would like to give Mr. Lekgetho to...
Without giving the name, I just want to get a sense of the seniority of the person. My understanding is correct, and secondly, the seniority of the person.
Yeah. Mr.
Thank you, Honorable Chair. From what we understand, the person is at an executive level.
Right. Okay.
Sorry. Chair, you asked the question whether the person facilitates.
Yeah. What they facilitate exactly.
I have to respond to that one as well.
What happened is that he just received a request, and if the document is sitting in another section, he makes sure that he send it to that section to collect the documents, and he give us the documents. So it's just to coordinate the collection of documents.
Okay. And just for clarity, and that person, and please don't name again, that person is usually therefore not an implicated person, because I can imagine if I have to provide information into myself, I might not provide it. So it's not a person of interest in the investigation.
Mr. Lekgetho, respond.
No, Chairperson.
Okay, no, that's good. No, I'm quite happy with that. Honorable Kubeka, let me give you an opportunity.
Yes, thank you, Chair. Chair, I think this is for Honorable something that Advocate Lekgetho said. He said when these investigations are done, they are done in the spirit of fairness, and people are given a right to respond. I've got a slight issue with that, Chair, because when the presentations are had here, for instance, in this committee, they become public knowledge. And when the right of reply is afforded, it's afforded after, like I had said before, newspapers and everyone else has lambasted and blasted people all over the media and social media. And I understand also, Chair, that you had said that names were withheld. But Chair, we all know who sits in the board of RAF, for instance. So when the board of RAF is being dragged in the mud for issues that they have not responded for, and when the CEO of RAF, for instance, or the CEO of another entity is being dragged in the mud for issues that have come up in these committees, I don't think that speaks to fairness, Chair. There's no element of fairness in that situation, because reputational damage gets done, people get fired, people's homes get wrecked over mere allegations. Thank you, Chair.
Thanks, Honorable Kubeka. I think we'll all need to take advice on this. I'm quite happy to do so, because we also have people appearing before the committee having allegations thrown at them in the moment without actually an investigation at all. And members are free to do this without any qualification at all. and they are expected to answer, and they do answer. So I'm quite happy to take advice. I take your point on board. It's primarily why I check these presentations because and this one was distributed a bit late because I just had to go through it to make sure that there were no names and that kind of thing. And the careful language is something that I insisted on, including a right of reply. So I think what we may need to do, and I'll take advice on this, Honorable Kubega, it may be that maybe the updates come at a particular point in the investigation. But it's always during investigations in any case. I do think in order for us to be consistent, it might be important for members themselves to also be mindful of when they make significant allegations to people that appear before the committee where they get the right of reply in the moment and they don't understand the substance of the investigation at all. We had that with the water and energy SETA chief executive. But I take the point on board, Honorable Kubega, and I'll ask the committee secretariat to just make sure we get proper advice on this, so that if we need to, then we are even more careful next time. So I'm not dismissing the point. I'm recognizing it and saying we'll take the necessary advice.
Thank you, Chair.
All right. So I'm done with my clarifying questions. There are some points I need to make, and it's just a comment. So the committee secretariat will work on bringing the Legal Practice Council. I wanted us to have this presentation about the lawyers, the portion about the lawyers here, because it's just one of those things that really gets to me because the sums of money involved are just massive. And it's just unacceptable that wherever there is an agency like this, there is a cottage industry of lawyers that make easy money by shuffling paper a lot of the time. So that is the first thing. The second thing we might need to do, and we might just need to work out which the relevant authorities, because ultimately also what we must care about as a committee is that people with valid claims are paid what is due and fair and according to legislation, and that is done as expeditiously as possible. The length of time it takes to settle these things is unbelievable, because there are people who really deserve. So there are corrupt lawyers on the one hand, there are issues with the courts and that kind of thing. And I saw a directive from Judge President Mlambo to say the matters must now go to mediation to try and settle as many of these matters as possible, just to clear the court roll. That's his perspective. But I also think as a committee, we must care about whether people who deserve a payment, and there are lots of crooks in the system who deserve a payment, get the payment, what is due to them. It's not an overpayment, it's paid on the correct terms, and so on, and that this is done. We will write to the minister to ask for some answers, basically, and I think the minister should appear before the committee at some point. I think it should be around the 28th, and I don't think it will be just about the RAF. There are several matters that are pending for the minister to come before the committee. So we might just need to bunch them up on that day so that we can deal with some of these matters appropriately. So, but I want to say once again, for those who are watching, the qualifications that are in the presentation are really important, and I actually insist on them personally. That where the investigation is, the stage of the investigation is important to clearly identify, so that people don't later on say, yeah, but you had said, these are preliminary findings, these are observations of what is contained in the evidence, but in the final stages thereof, where if the explanation is not satisfactory, the next step then takes place, which is disciplinary action, referral for prosecution or further criminal investigation, and so on and so forth. What I've also asked the committee secretariat to do is that we send a letter in my name to the Minister of State Security. So I don't want to just blame the Road Accident Fund here. The State Security Agency takes forever with this thing. That's been my experience. And it might just happen that the RAF's own vetting process is just going to fall into that morass. I don't know if there's a resourcing question or unwillingness to do it. But what is clear is that we also can't deal with instances where an institution has hired someone. There is publicly available information that screams, don't hire this person, or at least ask further questions, and they still get hired. And the state security agents, which is supposed to keep the whole country safe, hasn't done the work, and so on. So we just need to deal with that at a fundamental level. The last point I want to make is seemingly unrelated, but it is. You may have noticed, honorable members, that there was a reference to ransomware and loss of information. So today we're sending a letter to the Minister of Communication and Digital Technologies. There is a date we've penciled down. I think it's in 2 weeks' time or 2.5 weeks' time from today. For him, the Deputy Minister, as well as the State Information Technology Agency, to come and account for their own audit outcomes, as well as the dismal level of support they give to state entities like the Road Accident Fund and government departments and so on. It's just astonishing. And things like ransomware are so well known that they actually just shouldn't be happening, especially in an institution that processes large sums of money like the Road Accident Fund, and yet they happen. And that points to failures of a critical state agency that should do better. So I understand that as far as the rough accounting authority is concerned, cybersecurity and this thing is their baby. But at the same time, we also need to go to source where it's clear that support is inadequate to state institutions. So there is a date that's penciled in. If you consult the calendar that the secretariat has, or maybe you might need to update it since the hearing. But during the course of this month, we will have the Minister of Communication and Digital Technologies coming to account for some of the issues that have been identified there. I know we've run over the time. I want to thank you, Advocate Motibi, and your team for a comprehensive conversation and for your patience with my stupid questions at the end there, because I think these issues are important to clarify, especially for those who might be reporting as journalists and so on, that they report in context. And that's why I asked these questions as well, so that the information is hopefully treated with the type of care that it deserves, so that we don't create problems down the line. But I wanted to thank you for making the time, and and wish you well.
Thank you, Chair. Thank you, honorable members. We appreciate that.
All right, honorable members, thank you very much. I wish you a good weekend and a good week off next week. And it's been a long term, and may you get some time to recharge and come back fresh for Parliament when it resumes. So thank you very much for sticking with this through to Friday afternoon. Thank you.
Thank you, Chair. Thank you.
Thank you, Chair.
Thank you, Chairperson. Aye.
Recording stopped.
Denzel. Denzel.
Yes, Ntombi. Ntombi, can you hear me?
Yes, you know the department.
Ntombi,
Hi.
the streaming is still on the platform, so our conversation will be streamed.
Let me take it out. Can we